And currently, you are serving as a commissioner at the Public Service Commission of South Africa. That is from January 2013 to present.
That is correct.
You have been also a professor in public finance management at University of Stellenbosch, involving teaching honors students and masters and supervising doctorate students in research.
Correct.
You also have served as in the various committees of Parliament. Amongst them, you were the chair of the subcommittee which researched and wrote the Public Finance Management Act 1999. Am I correct?
You are correct.
And as mentioned earlier, you're also the chairperson of SCOPA.
Yes.
I see you also mention the fact that you have been involved in research and you have co-authored certain publications and books.
That is correct.
And you mentioned that amongst the books, you are the co-author of the best-selling academic textbook, Managing Public Money, first and second editions.
Correct.
And lastly, you say you have recently completed a university textbook on public finance theory and practice, which is due for publication in 2014.
That's correct. I'm not sure that the publishers will meet the deadline, but that's the plan.
Thank you, Dr. Woods. Let's then go back to your statement on page 2. In paragraph 3, you just mentioned that you have been subpoenaed to give evidence that may be relevant to the acquisition of armaments, which form part of the special defense packages. Is that correct?
It is, yes.
And you also confirm that the facts in your statement are correct and within a personal knowledge to a certain extent.
Correct, yes.
Now, paragraph 5, you give the purpose of your statement. Can you take us through that paragraph 5 to explain the basis of the statement that you've made to the Commission?
What I'm alluding to here is that there have been no smoking guns, no absolutely conclusive evidence of corruption in the arms deal that has been put into the public domain. So and being subpoenaed to appear before the Commission, I just want to make it clear that I do not have any smoking guns. But what I do have is a great amount of what we might term indirect evidence, or circumstantial evidence. Much of it based on allegations. I've been very selective with the allegations I refer to. They have to be substantive allegations produced by reputable people who can indicate that they have reputable sources. And it's all that evidence that I put together with some evidence which I would suggest to be more direct, informing and building a picture. I do this by building a number of arguments which I hope to convince the Commission as to the authenticity of those arguments and how those arguments ultimately fit together, how themes develop across and transverse those arguments, resulting in a picture which strongly suggests the probability of corruption having taken place in the arms deal. So that paragraph that you refer to is more about my approach and a little about my methodology.
Thank you. And in paragraph 6, you just mentioned that your statement is also made on the understanding that the Commission's responsibilities, both in terms of the Commission's Act 8 of 1947 and its terms of reference, go beyond simply accepting or rejecting the evidence it receives by those who testify before it. Can you just explain that?
I think it is exactly as it appears before you. I just want to put on record my understanding that the Commission has a job to do that is instructed by both the Act referred to and its terms of reference to conduct an inquiry, to conduct an investigation, its own investigation if necessary, and that the participation of us witnesses is simply to cooperate and to help you. And I would hope at the end of my presentation to have convinced you that there are some specific areas that that you should look at, and that if you were to look at them, that you are likely to come a lot closer to the truth that has been so elusive thus far.
Thank you. In paragraph 7, you're simply mentioning that your statement will be relevant in respect of the Commission's terms of reference 1.5. Is that correct?
Yes, I respect that the Commission was given terms of reference, and that would be a fruitless exercise for me to speak or to produce evidence which wasn't relevant to the brief. So I do offer here reference 1.5 of the Commission's brief as being the item which I am attempting to respond to in giving evidence.
Thank you very much. And now we're proceeding in from paragraph 8 under the topic evidence of wide-ranging corruption in the international arms industry. So in paragraph 8, you're trying to give that background. Can you take us through that paragraph 8?
Yes, Chair, I believe it's important, or perhaps essential, that that what the Commission is inquiring into here is a particular industry, and it's an industry that has its own history, it has its own reputation, it has its own way of doing things. And I think we have to recognize, as SCOPA did in its 14th report, the 14th report which gave birth to the first investigation, we there too said we must acknowledge that this industry is an industry that when we were looking into issues which are irregular, which might be corrupt, we need to bear in mind that it's an industry like no other. And I try to substantiate that as I've done throughout my statement, Chair, with a few references. If I could make a general statement that I have many thousands of documents of some degree of importance or other, and it was a matter of always trying to select a few which I thought would give weight or substantiate a point I was making. So in the case of me reminding everyone that the arms industry has its hard-earned reputation, that this is clear from a number of very deep research exercises, by statistics produced by the World Bank, by Transparency International, by other bodies, where it would seem there's consensus that it is the most corrupt industry in the world, and could corrupt for as much as half of the world's corruption, even though it accounts for only 1 or 2% of the world's trade. It gives us a sense of proportions, and it gives us a good idea of what we're working with here. And I think to bear that in mind, I thought was important for the statement I produced, and hopefully also for the Commission. But now I'm saying, notwithstanding its reputation, notwithstanding the huge collection of literature and research-based literature that's been produced on this industry. It would seem that the executive, in particular those executive members who made up what was called the Cabinet Subcommittee, put there by Cabinet at the time to oversee the processes, the structures, the practices that were utilized in evaluating all the bids for arms business for the SDPs, and evaluate and be part of the selection, the decision-making process. That those executive members in particular, through documents that I offer you, showed themselves to be ignorant of the nature of the arms industry. And there was a certain naivety. And part of this first argument will be that it was that naivety and that ignorance that caused them to take the eye off the ball and just to trust the processes and trust the officials who produced them, who produced information for them and produced recommendations for them. And the three instances I produce here are firstly extracts from a press statement issued by the Cabinet Subcommittee.
Are you referring to the extract on page 43 of the bundle?
I'm sorry, Advocate Mpaka. Dr. Woods, can you perhaps try and talk into the mic, because we are really struggling to hear you. You're not as clear as Advocate Mpaka is.
Maybe you can take us through that annexure, GGW2.
Chair, your technical man did warn me prior to that I shouldn't talk directly into the mic because it creates a distortion. So I'm trying to get the compromise here so that you get everything on record clearly, but also that, of course, that you can hear me clearly. Can I ask you, is that sufficiently clear? Thank you. Right. Yes, I am referring to the annexure number 2 on page 43. And if, I suppose firstly one could say it's the statements generally not acknowledging that the arms industry and its players were an issue, were even worth considering as possibly being people that you should be careful when you contract them with them, when you transact with them. I refer to the 5th paragraph, which is the second to bottom paragraph, where the government in fact expresses strong reservations on the statement made on prime contractors. And the only statement that was made was the one I referred to, where we, in our 14th report. Of course, they go on and to manipulate the statement and try to suggest that by making a statement we are reflecting on the integrity of the Cabinet Subcommittee. But if you look at the literal content of what we said, that is simply not correct. But they do show some resentment for the fact that we did offer a critique of the industry. We further, when 3 of the members of the Cabinet Subcommittee appeared before SCOPA, the issue again arose.
I think it's on page 57. You're referring to the comments which were made by the ministers at that hearing of the 26th of February 2001, Annexure GGW4, page 57.
Indeed I am, and on page 57, the third paragraph from Minister Alex Irwin, he says, I would just like to draw your attention, which is not the subject of discussion, but very relevant. Your opening remark and introductory comment, by many accounts, the international arms trade industry experiences a high industry malpractice. And I think there's a typographical error here. It talks about many countries being victims. Mr. Irwin goes on to say, it is fairly clear that your view is your predisposition as a committee that there will be corruption accordingly for those responsible for the prime decisions. Once again, you can see it's a fantastic manipulation of words on Mr. Irwin's part, but at the same time, it's being dismissive of the observation which we include that the arms industry is one that has to be carefully dealt with when you buy goods from them. Then I conclude a third reference, which comes from a letter which I think many have said is a controversial letter.
Before you go to that letter of the then Deputy President, can I also refer you on page 58? I think it's the comments made by the former Minister of Defense, Lekota, and I just want to hear your comments on what he's saying. He's on page 58, Chairperson and Commissioner Musi, the last paragraph of page 58. He says, this Committee of Parliament, one would assume that when it is faced with a matter like this one, whatever the World Bank may have said, I may think, for instance, that by the time they made that conclusion, they probably would have made studies of a number of cases. So they are drawing a conclusion like that at the end of an exercise like that. This committee has not in its history, I think, as such reason to start from this kind of premise in relation in this matter. My apologies. This committee has not in its history as such reason to start from this kind of premise in relation to this matter here. It is as good as a judge saying, who may have tried many cases, and now I am brought before such a judge, and he says, generally, I think Mosotho are prone to eat horse meat, and since this Mosotho is accused of having eaten horse meat, can you comment on this?
Chairperson, Scopa oversaw the accounts and finances of hundreds of government institutions. Different government institutions doing very different things. Some very personnel intensive, others not. Some very procurement intensive, others not. Some that interfaced, where public officials interfaced with the public in a very direct way, others not. These were all considerations that we bore in mind when looking at the next set of accounts and where it came from. And I think that happens in many areas of work, of investigation, of auditing. You consider the peculiarities of the particular department, institution, or industry. That's all that we simply did here. For Minister Irwin in the first place to say that by doing that we were prejudicing the inquiry and prejudging it and reflecting on the integrity of the Cabinet Subcommittee went to ridiculous lengths. Mr. Lekota's comments went even further to suggest that that we were altogether prejudging situations and generalizing. It's just very unreasonable for them to try and suggest that.
Thank you. I think you wanted to refer the Commission to the letter of January 19, 2001, which was addressed to you in your capacity as the chairperson of SCOPA, which letter was written by the then Deputy President, Mr. Jacob Zuma. It's on page 45 of the bundle. Can you refer us to specifics in that letter?
Yes, I continue on my argument that the executive was generally ignorant about the dark side of the arms industry, and that weakened their oversight and caused vulnerabilities in the processes. Vulnerabilities which I will later suggest and argue most probably led to corrupt activities. The letter that I'm referring to is a letter not without controversy. It was a letter written to me in the first person, and many references throughout the letter. What I'm saying is it wasn't referred to me as chairperson of SCOPA, even though some of the content might appear that way. Other parts of the content of the letter are directed at me specifically. It's a very hostile letter. And part of the controversy and the speculation was that the letter possibly wasn't written by the person who signed it. It was signed by the then Deputy President, Jacob Zuma. But the speculation is that it could have been written by the President at the time, President Thabo Mbeki. And I produced a number of arguments which raised questions. But of course, I don't know the truth to that answer. It is a bit unsettling. If it were to be written by Thabo Mbeki, it would be all the more improper. But either way, it was a member of the executive who makes many strong statements, but on page 48, the first paragraph, he takes exception to the 14th report having said, by many accounts, the international arms industry experiences a high incidence of malpractice, with purchasing companies often having been the victims of very costly exploitation. The writer says, with this in mind, the committee has considered the transactions and the broader financial and fiscal implications pertaining to the recent South African arms purchases. He says that in quoting SCOPA's report. But then the writer raises the question, who gave what accounts to SCOPA? And goes on to quote SCOPA having said, with international armaments markets having recovered, the committee feels that the large commitments by suppliers might now be resisted and even reneged upon, with South Africa unlikely to be a serious arms purchaser over the next few decades. This possibly needs to be watched closely. And there again, I'm challenged where he asks, what study has SCOPA done which shows the recovery of the international armaments markets and possible response to the suppliers in this development? Well, the simple answer was, in both cases, we did no study, because studies have been done by arms experts all around the world, and we relied on their experts to show that A, there was a large degree of malpractice in the arms industry, and secondly, that there was the cyclical nature of this market posed certain dangers. But more tellingly, if I can refer you to page 49, the third to last paragraph, where the writer, be it either Thabo Mbeki or Jacob Zuma, refer to the prime contractors as Blommenfoss, Thompson CFS, Ferrostyle AG, Thyssen, Noordzeewerke, Augusta, and Finmechanic, excuse the pronunciation, British Aerospace, and Saab. And goes on to say, and others. And it says, and the writer says, all of which are well known and prestigious international companies. Now, I would argue that that again illustrates and demonstrates the lack of insights of Cabinet in general and the subcommittee in particular of the nature of the industry. I have very quickly assembled a list, which is an annexure, of just a number of cases of either alleged or proven international arms deal corruption instances, which I'd be happy to respond to if required. Having spent a great deal of time in researching corruption, particularly in the public sector, for many years, but more specifically in the few years that I was director of the Anti-Corruption Center at Stellenbosch University, and having attended many conferences and having accessed much research on the subject, one accepts that the international contention that perhaps only about 10% of corruption is ever discovered, and that largely due to the secretive nature of corruption. That 10% it's further argued is considerably less than 10% when it comes to the arms industry, because the arms industry is the most secret industry in the world, and transactions are conducted in a considerably more confidential way than most transactions from most other industries. So my list just mentions a few of the exposés over recent times, bearing in mind that there's possibly many more.
Thank you. But if we go to page 50 of the very same letter, I just want to hear your response, Doctor. I think the then Deputy President writes there and says, natural justice demands that you both substantiate the allegation that the persons, governments and corporations we have mentioned are prone to corruption and dishonesty, and provide even the most rudimentary or elementary evidence that any or all of these acted in a corrupt and dishonest manner. And he continues to say, I believe that it is a most serious matter indeed for a parliament or any section of it to level charges of corruption against foreign governments and corporations without producing evidence to back up such allegations. What would be your response to that?
Yeah, I believe the writer would have been correct in saying that natural justice demands that I substantiate a statement. If that statement had been the accusation that the writers trying to make it out to be. But the statement is there in writing, and one can see that in no ways does it suggest that all of those that acted in a corrupt, dishonest way. There is no such suggestion at all. So I have to dismiss the comments made in this letter in this particular instance.
Thank you, Doctor. And I see on page 202, Annexure GGW 47, it constitutes your response to the very same letter from the Deputy President. Would you want to deal with specific issues from that response?
Yeah, I appear to have filed that letter out of order when I rearranged my documents. But yes, the letter which, with the response which I produced and as part of my evidence in the Shabir Sheikh trial, because the letter signed by then Deputy President Jacob Zuma was a fairly prominent issue in the Shabir Sheikh trial. So I was asked to give my views and give an analysis of the letter, which I did in the document you refer to. If you would want me to go into specifics of my response, I would need to borrow your copy.
Oh, thank you. But I see in the letter in paragraph 2 thereof, you mentioned that as the respondent finds it difficult to reconcile the character of the letter in question with that of the Deputy President, whom he has long held in high regard, the responses are made with some doubt as to whether the writer of the letter is of the letter in question. Is it not what you earlier said to the Commission, that you doubt the author of the letter?
Yes, I also said earlier on that, of course, I don't know who wrote the letter, but the then Deputy President Jacob Zuma was someone who I had met from time to time and had, on a number of occasions, either sat with him at a function over a dinner or sat with him in Durban Airport en route to Cape Town, and felt that I'd got to know him, and I just couldn't see the type of sarcasm in the letter. I couldn't reconcile that with a more gentle person that I'd come to know. So maybe my doubts are misplaced, but I did have some doubts as to who the author might be.
Thank you. I have given you the copy of your responses. If you want to maybe highlight any issue arising therefrom.
Well, there was, there were a catalogue of issues raised by, let's just say, the Deputy President in his letter, and I felt I looked at the letter, considered it seriously on its merits, but established there were many discrepancies with the truth on points he had raised, many manipulations, including important issues like the omission of the Special Investigation Unit from the first inquiry, the Joint Investigating Team's inquiry into the SDPs. I disputed that I had acted ultra vires in writing to the then President to ask him if he would consider giving a proclamation to the SIU. I took up the issue again on the international arms market. Other issues where I disagreed were the letter misunderstanding the government-to-government agreements. So I just wanted to correct the letter there. I also wanted to correct them on the argument that some ministers had claimed at the time that they wished to appear before SCOPA, but we had never had a formal request. The letter seemed to assume that we were rejecting these ministers. And it was later shown that when the ministers requested more formally, that we were happy to bring them before us and have discussions with them. Chair, I don't know if there are any specific issues that add too much value to the case that I'm building, but I would invite the chair or yourself to pick up on any issues you'd like me to elaborate on.
No, thank you very much for that explanation, Doctor. Let's revert back to your statement, paragraph 11 thereof. I think you have dealt with some of the issues arising from paragraph 11. Maybe if you can, we can go to page 60. You are referring to an article titled Corruption in Arms Trade there. I just want to find out from you which aspects from this article do you want to highlight on page 60 of the bundle. Page 60 of the bundle, it's an article, the corruption in arms trade.
I have it. I thought you were referring to the list once again. One observation I just draw to your attention from the list, as I say, is a relatively short list, but hopefully it's sufficient to prove my contention that the arms industry, that corruption pervades the arms industry. And you will notice amongst arms suppliers who have been strongly alleged to have been corrupt or have been proven to be corrupt, a number of the suppliers which supplied the arms packages in our case, in South Africa's case, so happen to have their own hard-earned reputations in that regard. Moving to the document on page 60. Again, I could have produced books and volumes and boxes of documents and papers, but to show that there is a consensus view across people who research the industry that the industry has the problems I've referred to. So I just took an example here of one such article. But the article, in addition, refers to the issue of commissions, which we will come to in one of the second or third arguments that I will build shortly. So it's just to indicate that it's not just me saying these things, that there's a body of literature out there that is research-based, that substantiates what I'm saying.
Thank you. And I see on paragraph 11, you also make a reference there to annexure GGW6, and the background thereof is that you indicate that 32 connected individuals who received discounted motor vehicles in South Africa from an arms supplier would be typical of such influence seeking by the suppliers. Can you just explain that?
Yeah, if we study corruption in the arms industry, there are possibly 6 or 7 types of corruption that are common to cases that have been analyzed and proven. But at the top of that list is the issue of bribery or kickbacks, most often referred to as commissions. How those bribes or commissions were administered, I suppose in much the same way that happens in other industries that government might do business with, or industries that might do business with each other. Bribes are paid to secure business. But they can happen from 2 ways. It could be the purchasing company, and it could be an official in the purchasing company say, I want to receive a bribe, so I will initiate that possibility with the supplier. In other words, he will say, I'll make sure you get the deal if I find a Mercedes-Benz parked in my driveway next week. But more often than not, it would seem that it's initiated the other way around. It's the supplier who looks at where the prospective business is. And in the arms industry, we have people who are very skilled, who do an awful amount of homework, will study a government where it's a government business. They will look at how the decisions are going to be made, and most importantly, they'll look at who's who in the overall process. And in identifying those individuals, they'll have ways of giving them sweeteners or small bribes, often with the promise of bigger things to come, as the deal takes shape and as they, the supplier, become increasingly the preferred supplier in the minds of the decision makers. So it is in explaining that theory, I just thought I would include this list, which is a factual list of 32 individuals, either South African politicians or public officials. There are a few on the list which are undisclosed because the arms steel employee concerned here, a senior person, sometimes bought these motor vehicles in his own name for onward distribution. Who they went to, we don't know, but there are enough names there to show us how strategic and how insightful bribe payers can be in finding their targets and in building their influence from there. I know this case was cut short simply because the National Director of Public Prosecutions refused to continue with it. I went and fought with him personally, and he showed no interest. I could elaborate on that. Should I? Yeah, it was said that everybody who received a car could produce an invoice showing, yes, they'd got a modest discount. So from that paperwork, they felt there wasn't a case to. But I happened to have known one of the recipients and managed to extract from him that there was a massive kickback on all those vehicles. As can happen in the real world, there might be Ford, for example, who will have an advert in the newspaper saying, buy your new car from us and we'll give you 10,000 in cash. Because, as I tried to suggest to Mr. Ngluka at the time, that it's simply ridiculous to believe that this select group of people who are so particular to the decision-making process of the arms deal that only they were chosen, and it just so happened that everyone just happened to be in the market for one of the cars that was in this yard, and they all bought these cars. You know, it just goes beyond the bounds of what is believable. But unfortunately, the case wasn't followed through on, as were none of the cases. So over 100 cases given to the NDPP came to naught.
Chair, I see it's about 11 o'clock. I'm not so sure we should proceed.
Maybe let's go on until 1:15.
Thank you, Chair. Dr. Woods, thank you for the explanation. Let's proceed then to paragraph 12. I think you have spoken in detail in respect of the corrupt industry, the arms industry being corrupt, and reference to the Transparency International, the World Bank, and U.S. Department of Commerce. But of interest, I just want to refer you on page 6, then you make a reference to annexure GGW7 and make then allegations that previously there were dubious transactions by BAE, Ferrostal, Thomson, CSF, and SAB. Could you just elaborate on that?
Chair, perhaps I had been moving a little ahead of myself, but I have been making reference to that list, to the GGW7, and pointing out that certain of those arms suppliers the arms suppliers within our package, our SDPs, happen to appear, in particular BAE. You know, I'm aware that not all of the cases were proven. There was the BAE case in Saudi Arabia, the Yamamanan deal.
Are you referring to GGW7 on page 65 of the bundle?
Yes. So I just want to make it clear that not all of these cases were proven. The majority of them were. But sometimes the reasons for them not having been proven are worth taking note of, like the Al Yamaman deal, where the deal, much to the disgust of the Serious Fraud Office in the UK, was stopped by then Prime Minister Tony Blair, giving us his reasons that it would bring embarrassment to the British and Saudi Arabian governments. The SFO made it clear that they had a conclusive case.
Just hold on, Dr. Woods. What is the source of the information which is contained on this page 65?
You may proceed.
Chair, I misheard you. The page you're referring to?
Page 65.
Chair, there are various sources. These are claimed in many books written on the subject, many articles. So many press releases, But there are all cases where there's no contesting that the allegation is made here, especially in the cases of those that have been proven. So, so various, what I say, reputable sources.
Dr. Woods, my question is simple. You have given us a document here. This document contains certain information. What I'm trying to find out from you is, what is the source of this information that we have put before us? It's on page 65.
Roger, as I said, there are various sources. I haven't accompanied the page by details of those sources, if that's what you would have required.
Thank you, Doctor. Maybe let's proceed then to paragraph 13 on page 6. Then you are alleging there that for the South African government to claim without any substantiation that the South African arms deal was somehow different to so many other arms deals in terms of possibilities of corruption, without giving any reason as to why this could be the case, is not easy to accept. The denial of any possibilities of corruption in the SDPs by the former members of the executive who have appeared before this commission is therefore incomprehensible. Do you want to expand on that?
Yes, there were many statements by government, including in the press statement that I referred to early on, where they were adamant that no corruption took place in the South African arms deal, and the corruption simply was not possible. And paragraph 13 is my bringing into question, how could they have been so sure, given the arms industry and what it has often proved to be? Why do they think that the South African arms deal was different, was not vulnerable, was not susceptible to corruption, as so many others have been? Again, it depicts a naiveness on their part, and without them giving any reasons as to why our particular arms deal was so meticulously managed. One has to call into question this denialist attitude of theirs. That leads me to the next paragraph, where I say, this leads to the question of why the executive on one hand is so aggressively adamant that the SDPs were free from anything dishonest, but on the other hand were equally as aggressive in their display of anxiety about any investigation into the integrity of the SDPs. There seems to be a contradiction in their behavior there. I thought that if the executive were so confident of the integrity of the arms deals, they would have opened their arms wide to any investigation. But they did the opposite. They went to extraordinary lengths to sabotage the investigation and sabotage those who oversaw that investigation.
Thank you, Chair. As we are starting a new topic on page 7, maybe it may be the right time to take an adjournment.
We'll adjourn for 15 minutes. Thank you.
Do you confirm that you're still under oath? If you do, say I do.
I do.
Thank you, Doctor. Can we proceed then to page 7 of the bundle? Your statement. I think you're dealing there with a new topic titled, Was there corruption in the SDPs? And you start by referring to a subtopic, Roman figure 1, findings from a number of international investigations. Can you take us through that?
Yes, Chair, now I try and build my second argument. It's the argument to try and shed light on the big question. The big question was, given what we know, given what's in the public domain, do we have reason to believe there was corruption in the STPs? I will refer to a number of allegations, cases, findings, investigations, but hope to do so in a way that they coalesce into a bigger, almost self-reinforcing picture where themes develop, where we start to see patterns, we start to see personalities, we start to see certain common types of behavior, and altogether that we come to acknowledge the probability that it can't all just be nonsense. I'll do it in two parts. The first part concerns investigations that relate to the South African arms deal that were undertaken in other countries, namely countries of certain of the suppliers of our arms deal. I will just refer to the main ones. I've established that there have been other smaller international investigations, some in-house, the findings of which are there, not too well known. But after having dealt with that, the international findings, I will then turn to some other allegations, another set of allegations, which again, most of which we would have heard about. I'm quite selective about the allegations I refer to, because I don't want to waste your time with wild allegations, unsubstantiated allegations. And as I said in my opening remarks, here too I will only refer to allegations which I believe we can say have some basis. And it's those two parts together, the international findings and these allegations, that when we put them together, I hope we can conclude that it's reasonable to believe that corruption took place in the South African arms packages, perhaps on quite a wide scale. I begin with the international investigations. And here I'm quoting from sources which are in the public domain. So I think and the investigations which cover BAE, the Saab deals, and Ferristar, and one of the common themes is that they all seem to refer to dubious payments which were made by the suppliers. Payments that were made to South African politicians, public officials, arms deal related businessmen and other middlemen. And I begin with a specific German investigation into Ferristar. May I just continue?
As I indicated previously, that the report that is mentioned in paragraph 16, subject to the commissioners, is subject to attorney-client privilege, So insofar as you refer to it, just be conscious of that. But you may proceed to deal with it, and where you stray away, I think the commissioners will be able to guide us.
Thank you for that advice. Yes, I'm referring to this particular case where findings are in the public domain from what was supposedly a leaked confidential document. So I appreciate the sensitivities around that. But nonetheless, those allegations are in the public domain. They do have substance, and I would want this opportunity to at least place them on record and to ask the Commission that they do reflect on them. So there was the audit by a US-based law firm into the Ferrostyle deal, which amongst other things showed that Ferrostyle had close links with Chippy Shake. We'll find in other evidence I provide later on that link between Chippy Shake and Ferrostyle crops up all the time, as does Chippy Shake's links with other suppliers. And that's, I'd like to register as one of the themes which I'll build up to and then give some direct focus on towards the end of my presentation. And it regards the building of submarines, where the allegations are of amount of $40 million being paid to agents in South Africa, and where the leaked report is reported to say the chief attraction, of these payments was their influence on politicians. And I refer you back to my earlier illustration of how bribes work and who they target and for what reason. Just to give some detail to this particular investigation, I refer to an annexure GGW 8.
On page 66. It's on page 66 of the bundle.
Advocate Mpara, just before we pass this point, I see this is an article by Mail and Guardian. I'm not quite sure what is the evidential value of that article from Mail and Guardian. I'm really not sure, unless if it's all the journalist who wrote this report comes in and testify. Otherwise, if it's all just an article from Mail and Guardian, I'm not quite certain about the evidential value thereof.
Thank you, Chair. As you've heard the chairperson, what value do you want to attach to this article which you have referred to in the Mail and Guardian?
Well, in that the contents of the article have not been contested. The fact that there was an investigation, even if the findings were leaked, has not been contested. So I believe it amounts to allegations that we should take cognizance of, and that, as I requested, Chairperson, I would like to have put on the record. They also are allegations which, as my evidence unfolds, you will see give credence to other allegations and offer a certain consistency of particular events which developed around the Ferrostyle submarine deal. So hopefully I'm replying to your question and answering what I believe the relevance of this Mail and Guardian article is.
Chairperson, we object to this particular account in the Mail and Guardian. It has lots and lots of allegations which do not add to the issues or elucidate the issues that this commission has to decide. I'm referring, for instance, to the allegation on page 67 in the Sunday Times, reported that Ferrostal allegedly gave former President Thabo Mbeki 30 million rand in bribes, and that after sharing this with Jacob Zuma before he became president, Mbeki gave some of the money to the African National Congress as a donation. Then Mbeki has denied the claims. What is the value of this, apart from just throwing mud?
Mr. Chairman, if I can come in here, we are actually dealing with an issue that we've dealt with in quite some detail with Mr. Mainier's evidence, and you've made a ruling there. It appears on page 7943 of the record, where I raised the same issue that you have now raised and that Mr. Morane dealt with reference to my client, Mr. Shlongwane and Shlongwane Consulting. We studied the submissions by this witness, and actually there's not a single aspect raised in the submission that's based on any admissible evidence. The witness clearly doesn't have any knowledge of facts, and he relies on mostly Mail and Guardian press statements and articles, as well as a email emanating from Mr. Mainier. And with great respect, I submit that at this stage you maybe should give us some ruling again as to what the status of the evidence that this witness is now alluded to is, and whether it is admissible in any way. It clearly doesn't contribute to your proceedings. All that he tells you, definitely relating to my clients, is what the press in certain press statements said. I will, in further reference, when we come to it, indicate to you, but I've checked all the sources that he relies on, and it all emanates from press statements and press releases.
Dr. Woods, before you respond, maybe let me point out to you that we have received correspondence from Weber Wenzel where they told us that the report at Davis Oplinton, it's still under clients and attorneys' privilege. Their clients have not waived their rights to that document. In the light of that, you want to respond to what the two advocates have said. Basically, what they are trying to say is that, by referring us to press statements without adding anything to that, that is not quite being helpful to the Commission, because we don't know what value is being added by various press articles, because we are trying to make factual findings at this Commission. Do you want to respond to that before we proceed?
Chair, I of course accept your ruling. So I will divert my attention from the leaked report in question. But I will say that issues that will come up elsewhere, or Ferristal's relationship with Chippy Sheikh. The fact that the German Public Prosecutions Authority did an investigation into Ferristal is a fact. That Ferristal then commissioned an investigation to investigate why there were so many, not only allegations, but proven instances of bribes being paid, which in turn led on to this investigation, which, as I said, in respect for your ruling, I won't entertain further. But a number of these issues that are raised in this report will come up through other sources later on in my investigation.
Dr. Woods, do I understand you to be saying that the Germans haven't investigated? You say the Germans haven't investigated, or are you saying that they have investigated? Maybe I misunderstood it there.
Chair, there's with original investigation, which is referred to at the bottom of page 66, where it says that this American law firm was hired to clean up Ferristal following a series of corruption scandals and the arrest of one of its board members by the German Public Prosecutions Authority last year. The German Public Prosecutions Authority produced a report. That's what I'm referring to, Chair.
Dr. Woods, as far as the report from this law firm we're acting for Ferristal, I think I have already made a ruling there. So that report at this stage is not admissible. And two, when you deal with the newspaper articles, bear in mind the question that I've asked, and which is, of what value is those newspaper articles going to be to us? I think if we can proceed, but then bear those two things in mind. Thank you.
Thank you, Dr. Woods. Maybe then let us proceed then on page 8. You were now dealing with the German investigation of Tyson. Without reference to the newspapers, based on your knowledge during, as chairman of SCOPA or during the investigation, just to take through those topics without making reference to the allegations raised in the newspapers. I'm just saying that, are you able to assist the Commission with reference to the subtopics that you have mentioned under the Roman figure 1, 2, 3, and 4, without even making reference to the press statements?
This is starting on page, yes, I'm still battling with, while I of course accept your earlier ruling, Chairperson, I'm just trying to make sure I understand the way it preempts my further evidence coming from press cuttings. I believe everything.
Dr. Woods, I'm not preempting any further evidence. If we do have evidence, we would like you to give us that evidence. We're just referring to you reading other people's reports, and we have told us that, you know, those reports are still subject to client and attorney privilege. We are not stopping you from reading any evidence, and we are saying to you that as far as newspaper cuttings are concerned, just bear in mind that, you know, we are a bit worried about the evidential value that must be placed on those articles, because those are purely newspaper articles. You are not the author of those articles. You cannot tell us that those articles are correct in all respects. Just saying that, you know, you must bear those two issues in mind when you justify. I'm not stopping you from giving us evidence. If you do have evidence, give us the evidence. Give us the evidence.
Thank you for giving me that clarity, Chair. A lot of my evidence will come from newspaper articles. As I indicated earlier, there will be carefully chosen articles which I believe offer substantive allegations. By virtue of who wrote the articles, by virtue of the content of the articles, where they got their information from, the investigation they did. So it's not something I can just dismiss because it's a newspaper article. In a sense, it amounts to research. So it has substance, it has, very often has credibility. And I also explain my approach of accumulating such evidence in order to show bigger pictures and patterns. And so we might not be of one mind here, where I believe these ultimately together add a lot of value and paint a fairly strong picture. As I go through them, it might not appear that way to anyone listening to what I'm saying. So I hope you'll give me that bit of latitude, Chair, that I am trying to use methodologies which are well established in producing knowledge. I have a strong background as a social scientist, our job being to produce knowledge in a different way to what the legal fraternity do. So I might just need a bit of understanding from you as I go through.
Okay, we may proceed then.
Just hold Advocate Park. I don't quite follow what Dr. Woods is saying. At the end, he said that no, we should just give him a leeway. I didn't quite understand what he meant by that. Can you just explain again, Dr. Woods, if you don't mind?
Yes. Chair, I think it would be disruptive, and if I was to be challenged on each newspaper article I quoted from, on the basis that it was just a newspaper article. So I'm trying to reason as to why these are not just newspaper articles. Why in the biggest scheme of my presentation, they offer, in many cases, a fairly compelling picture. So I'm just asking you for a little bit of grace in allowing me to present excerpts from the press articles which are amongst the items in my evidence bundle.
Okay, you may
Thank you, Chair.
I think we're dealing with Roman figure 3. You may proceed on page 8 of your statement.
Yes, fortunately, the client attorney privilege only happens in one case, so I'm pleased that that shouldn't get in our way again. The German investigation of Thyssen I refer to, where the Office of the Public Prosecutor in Düsseldorf investigated the GFC and an alleged $25 million paid, in which it was said most of which flowed directly to South African officials and members of the cabinet. It's also said another $3 million was paid to former Chief of Arms Acquisition, Chippy Sheikh. Now I have to be careful here because I would hate something to be coming into this investigation that in fact also existed in the investigation which you've ruled against. So I'd have to be guided there.
Dr. Woods, before we pass this paragraph, I'm quite interested. I see you make a very interesting thing is mentioned here, where it says that, most of which flowed directly to South African officials and members of the cabinet. I'm quite interested to know who is the member of the cabinet who benefited from this, who got part of this money. I'm sure it will really help us a great deal to deal with some of the difficulties that we have. If you can be in a position, if you do know, tell us exactly who the cabinet minister is who might have received this money, if you don't know.
No, that's a very fair question, Senator. I'd like to pick up with the issue that was raised early on. I agree, and if I had been allowed to entertain the previous document, I would not for a moment have referred to that Sunday Times article. I have no knowledge of funds having flowed to the cabinet, especially to the president at the time or the deputy president. I do have some evidence regarding monies having flowed to the late Minister of Defence, Joe Modise, but not to other cabinet ministers. So even though that's what a report might quote, the issue I'm not trying to raise here, I'm just trying to raise, was there corruption? And if it says there were dubious amounts, substantial amounts paid by suppliers to parties in South Africa, that takes me as far as I want to go.
Dr. Woods, let me understand what you're trying to say. Am I correct to say that you are now saying you are not aware of any cabinet minister who has paid part of this money? Am I right to say that you are not aware of any?
Yes, Chair, but I am aware of benefits, whether it was through these monies or in other forms, that were paid to a cabinet minister at the time, the late Joe Modise. But the rest of the cabinet, I say, I have no knowledge whatsoever of any of those, and in my personal opinion, I doubt that any of the other cabinet ministers would have taken money. I separate the case of the current president's case because that was very peripheral to the arms deal. It was very peripheral to the transactions that led to the supply of the arms. So in addressing your question, I believe the cabinet ministers, besides Joe Modise, and concerning commissions, bribes paid, I personally feel it's very unlikely, and I don't believe any of them did receive any money.
Now, let me be direct again. Concerning Mr. Joe Modise, what evidence is there that he received money? Now, I'll tell you why I'm asking this question. Because we are trying to look at various areas where we can possibly find a trace of that money. Can you be in a position to assist us any further, except just saying that Joe Modise received money?
Chair, I chose my words carefully, and I never said the late Joe Modise received money. I said benefits. And there we can talk about benefits, whether it's, whether it's his shareholdings and a number of other issues which I do intend to touch on. But I would like to distinguish between suggesting that he took a bribe or received some other favors.
So do you understand that you were saying that you never said Mr. Joe Modise received any money as a bribe?
Correct.
Now you're saying that he received benefits.
That's right.
Are you in a position to give us full details of those benefits so that we can try and make a follow-up?
Certainly, Chair. Would you like me to move on in my presentation to where we start dealing with those issues?
You can do it the way that suits you, as long as at the end of the day, if you can, then you tell us about the benefits that Mr. Modise has received out of this transaction so that we can make a follow-up.
I'll do that, Chair. Thank you.
Thank you, Dr. Woods. You were dealing with paragraph 7 of your statement. Have you dealt with all the issues you wanted to deal with, paragraph 17?
Yes, I think It was information which came about through an investigation by a credible source, the Office of the Public Prosecutor in Düsseldorf, and I'm simply making the point, which I'll be making over and over again, that dubious monies were paid by suppliers to parties involved with the South African arms deal. I don't need to go beyond that point here. I have a collection of background documents if you wanted to indulge detail, but that's not, I'm just trying to build a case that there was probably corruption, given all that we know.
Thank you.
Just asked about Annexure GGW9 on page 72. You refer to it as support for the averment that Shippy Sheikh was paid $3 million US dollars. Can I ask you, have you got it? Annexure 9 on page 72. It appears to me to be an email, a document. Who's the author of that email?
Yeah, Chair, there's, Commissioner, I beg your pardon. There are a number of databases that have focused on the South African arms deal. IDASA had one, the Institute of Security Studies had one, I think Politic Web and the Marburg has one. And yeah, an individual, Richard Young, has one. Part of a free service which Richard Young offers whoever's interested is that any arms deal related press statements, in this case one by James Marburg of Politics Web, he will distribute to a distribution list he has, which is quite a considerable list, I believe. So the email comes via Richard Young, but that is irrelevant. What is relevant is that there's an article written by James Marburg and who discusses the case, the investigation I referred to a moment ago.
So the author is James Marburg.
Yes, Commissioner.
The document was sent to you by Mr. Richard Young.
That's correct.
Do we know something about who James Marburg is? And in what capacity is he writing this?
I don't really, Chair. I believe that he's something of an expert, however one might define expert, on the arms industry, and has, amongst other military issues, seems to have some interest in the arms deal, and over the years has produced pieces from time to time concerning the arms deal, and then this would be one of those. But I'm afraid I can't offer you more than that.
Thank you.
Chairperson, our objection to this Annexure GG1 will follow that we raised with regard to GGW's 8, and for the same reasons too. There's lots of mention of President Mbeki here and what he's alleged to have done or not done, but no real evidence, and I don't think we'll be seeing Mr. Marburg before this commission.
Thank you, Chair. Chair, I think Mr. Moran has raised a very important point, but I thought that the probative value in terms of evidentiary value of those press statements may be issues that the Commission may decide later on when it considers the totality of the evidence. At this stage, I don't see any prejudice because these publications have been in the public domain, and I guess for progress' sake, we may carefully refer to those press statements, but the Commission will have, at the end, be able to determine the evidentiary value thereof.
Mr. Chair, sorry, if I can respond to what has now been stated. With great respect, it is a rule of the law of evidence that if evidence is being presented to a body like yours in court, which has no value, evidential value, then it becomes irrelevant, and that makes it inadmissible. So it's not an issue where we can proceed and allow it and then subsequently make the decision. The problem that we have is that very serious allegations are made against various individuals and entities in these submissions based on absolutely no source and or personal knowledge from this witness. And on that basis, I would respectfully submit that the evidence that is being tendered based on these newspaper articles and or persons that this witness doesn't even know and cannot stand in for reliability, etc., should not be allowed. It's simply inadmissible, as you please.
Advocate Parker, just before you respond to what Advocate Celia has said, let's look at page 69. The email, apparently it comes from somebody else who then sent it to Dr. Young. Dr. Young would then send it to a list of a host of other people. And the original author of this document, we don't even seem to know who it is. Doesn't that demonstrate the point that Mr. Celia is making? This one, I mean, you know, Dr. Woods got it from Dr. Young. Dr. Young got it from so-and-so. So-and-so got it from so-and-so. And I'm not quite certain whether are we going to come to a point where the author of this document comes and testifies about the veracity of this document. Now, if that is the position, if it's on a newspaper article, a lot of people's names have been mentioned in there. And we're not certain whether the journalist will come and testify. What then becomes the value of that document? There's the first thing. Then the second thing is a question of relevance. I'm not quite sure how do you suggest that we should deal with it. You know, it's easy to say that, you know, you can look at the evidential value of the document at the end of the day. But in the meantime, people's names have been mentioned. In the meantime, people's names have been mentioned without any foundation, unless if at all at the end of the day, they, you know, are given evidence which supports the basis on which that article is based.
Thank you, Chair. Chair, I was just making a submission on the basis just for us to be able to progress. But I get the points. I mean, the issues that are raised are points of law. And I'm saying this carefully because I'm not acting on behalf of Dr. Woods also. No.
Thank you, Chair. It is not so much a message as the Chair suggests. I was making a point to Advocate Zondi in response to a very limited issue the Chair had raised, and I think the basis on which Mr. Moerani's objection is based. And that is that these documents place out their names of people and make allegations. The correction I was seeking to make is, if they are newspaper articles, The allegations are out there. So it is not like through this witness or through this process, the allegation will be made. There are newspaper articles, they've been published, they've been highly circulated. It is really a reiteration of what is already out there. If there is to be a debate about the value thereof, I believe it must center around whether any reiteration is necessary in this commission, but not to suggest that for the first time the allegations are being made. I'm not leading Dr. Woods, I am not involved in his testimony, but I do not understand an objection that reference cannot be made to an article that has placed a name out there. To some extent, I agree with Advocate Mpacha that the commission will determine the evidentiary value thereof in the fullness of time. However, as a commission, I believe that the commission is entitled to take on board all sources of information, and the commission is at liberty to consider even evidence that at first blush would be inadmissible in a court of law. This commission is faced with a whole number of allegations made from different sources. The question for me is whether witnesses that appear before the commission can substantiate those allegations. The fact that the allegation was made in the newspaper is not the issue. The issue is whether or not that allegation can at any point be substantiated. So personally, I don't believe that there is any expose that can be made unfairly through reference to articles. The articles are out there. They've been published over the course of the years. They have been read. Maybe this witness must explain why it is necessary in delivering his testimony to make reference to those articles and where those articles assist him. But a complete ban on reference to articles is what I personally was struggling with, and that is what I was telling Advocate Zondi, Chair.
I understand what you're saying, but then I think I'm still making that point again. If it's all an article, people's names have been mentioned, there must be a reason why that person's name has been mentioned. Two, we must be satisfied that there will be evidence which will support the allegation which has been made in that newspaper article. Short of that, I think it will be unfair to say that because your name has been mentioned in the past, we can continue doing that. I don't think that will be fair to those witnesses. We must be very careful when we deal with newspaper articles, particularly with a document like this one that I've just referred Advocate Mpacha to, where there are about 4 or 5 people in the middle who prepared something which ultimately ended up on our desk. And we're not certain whether any of them is ever going to come and testify. So I think we can allow some limited reference to this document on condition that people's names are not brandished around, unless if at all there's going to be evidence to support that. I think this is what we're going to do now, unless if at all there are other people who feel uncomfortable about this ruling.
Mr. Chair, now maybe just to indicate to you why we are concerned about the evidence in this regard. If I can refer you to page 87, for instance. That's another, it's exhibit GGW12B. That's another email apparently emanating from Mr. Richard Young. And basically the gist of the allegations against my client, Mr. Shlongwane, is to be found in this email. If you look at a paragraph in the middle of the page, it starts off with a quote, "The consultant who received the secret payments is reportedly Fana Shlongwane." And then it's alleged that he received up to 200 million rand in commission relating to the acquisition of 26 Gripen fighter jets. That's clearly allegations of a very defamatory nature, accusing Mr. Shlongwane of corruption. But the interesting part, Mr. Chair, if you look just further, who's the source of this information? It's Mr. Meinier. Mr. Meinier already testified to you that he has no knowledge of this. He doesn't stand in for the truthfulness of these allegations. He doesn't stand in for the reliability and or correctness of any of the newspaper articles and or documents that he relies on. But what we have now is a repetition of that by this witness relying on Mr. Meinier. And with great respect, that leads to some extent to an absurdity. The repetition of inadmissible evidence doesn't make it relevant and or admissible.
I'm sorry, where does it appear that Dr. Young got this information from Mr. Meinier?
Mr. Chair, if you turn to page 9 of his submissions, paragraph 20 is basically the gist of the very serious allegations against Mr. Shlongwane. Paragraph 20 on page 9. And then as his source that he relies on, he refers to GGW12A, which is a newspaper article, and GGW12B, which is this email. If you look at 12A, then it doesn't assist much in this regard, but 12B forms the very basis of this serious defamatory allegation against Mr. Shlongwane. And if you look what the source of this witness is, then it's Mr. Meinier, who already said he doesn't know of it, he has no knowledge of it, and he doesn't stand in for the correctness and or the truthfulness of this. And in the process, Mr. Shlongwane is being defamed in public based on this, with great respect, baseless sources quoted by this witness, as you please.
Advocate Park, do you want to respond to this one?
No, Chair, I agree. We have not necessarily, at this stage, come to that part that Mr. Lewis is referring to. And to avoid that, I think Mr. Woods would have to be able to give evidence without necessarily referring to those press statements in order to be able to avoid, as Mr. Lewis says, some defamation. But what is important, Chair, is that this is a commission of inquiry, not necessarily a court of law, and it's an investigation to inquire into. And I understand the concerns that are raised at this stage. And what I want to repeat is that these are newspaper articles that have been in the public domain. And I think that the very fact that Mr. Woods is referring to these articles does not make them new allegations. And it is for the commission to determine, after we would have given evidence, whether they'll place any value in his interpretation of the press statements.
Let's look at the question of relevance. Mr. Celia says that Dr. Woods relies on a particular document, and the author of this document relies on Mr. Meinier as the source of the information. And Mr. Meinier, we know that he was a certain know nothing. Now, where does that put this document? Are we going to go through documents which clearly will not help us in any way, which are totally irrelevant, simply because it's a newspaper article which has been attached? I think what we are going to do, and I think maybe in order to have progress, you can make reference to those documents, but then just be careful. Just keep in mind what we have said, particularly those that it is clear that there cannot be any, that is not likely to give us evidence which is going to support the allegations contained in those articles. Okay? I mean, maybe let's proceed on that basis.
Thank you. Dr. Woods, do you want to make any comments to the debate, or you are happy to proceed?
So I do, Chair. Firstly, I take exception to Advocate Salier's.
Dr. Wood, if you don't mind, can you speak directly into the mic? We're struggling to hear you. Perhaps
the technical people could turn the volume up a little. Chairperson, I take exception to Advocate Salier's suggesting that what I'm presenting is not evidence and it doesn't add value. It's a subjective comment. He doesn't know where I'm going with this. I don't know what his motive is, but I have explained on at least 2 occasions this morning that I'm building a case, and across all these documents I refer to, press statements and others, that a picture will emerge which I will support.
Dr. Wood, let me help you. Advocate Silier is representing Mr. Hlongwane's interest on instructions of a firm of attorneys. Now, I think that is his motive. I don't think he's got any other motive except that one. He's an advocate representing a client's interest on instructions of a firm of attorneys.
So, okay, I concede that it's his right to be disruptive. Secondly, Chair, my evidence is contained in my statement. In each paragraph of my statement, I raise an issue. To show that I haven't just sucked this issue out of the air, I supply some documents, which is often comes from my press article. As I've said repeatedly, I've chosen my press articles carefully. And am I expected to take a press article and cut one single paragraph out of it which relates to my press statement? I thought I was going to have the opportunity, as the my witness leader here is guiding me, my evidence leader, to show you which paragraph on the press statement. If some people want to entertain all sorts of other obscure and irrelevant paragraphs and make an issue of it to try and discredit my evidence, and to have you rule that I cannot produce this evidence, then I'm not sure where we're going here.
Thank you, Dr. Woods. Maybe let's proceed then, and where necessary, if we can avoid making reference to press statements, let's do so. I think we're done with paragraph 17. We were now going to proceed to paragraph 18 in relation to the SFO investigation into the BAE.
Just on paragraph 17 and on GGW9. Correct me if I'm wrong, but as far as I could see, this information relates to the Office of the Public Prosecutor of Düsseldorf, Germany. It does not relate to the subsequent investigation, the one which you have instructed me not to quote from. So I believe I have the right to quote from this document. But I just want to be assured that
Are you referring to the newspaper cutting on page 72, Dr. Woods?
yes.
What particular reference do you want to quote? Maybe you can just refer the Commission to the specific paragraph.
Well, they refer here to the German investigators. You know, they claimed in a letter for assistance to Swiss authorities last year that the consortium had paid considerable bribes to achieve the conclusion of the agreement. They refer to the amount of the bribes and the kickbacks, who they were from, and to the letterbox company in Liberia to whom it was paid. It mentions in that investigation $3 million the investigators allege had been paid to the former chief of arms acquisition, Chippy Sheikh, through another letterbox company. It mentions the name. It also mentions that the primary focus of this article will be on the ship platform equipment. And it goes on to bring up the issue of Bazan, who I will later argue unfairly lost the deal to. So, thank you.
Thank you, Doctor. Then let's proceed then to paragraph 18, the SFO investigation into BAE. Can you just take us through that paragraphs?
Yeah, documents relating to this investigation showed that showed US bank statements relevant to BAE that paid over £15 million to advisors in order to assist in securing and maintaining the South African Hawk and Gripen contracts. It says between September 2003 and January 2007, Hlongwane Consulting was paid in excess of £10 million by BAE. The SFO investigation revealed that Hlongwane also received 51 million South African rands in an agreement with the South African registered entity. In relation to this, on the 9th of June 2003, the British Trade Minister, Patricia Hewitt, confirmed to the House of Commons, so this evidence will be in the British Hansard, that BAE Systems had paid a commission on its contract to supply Hawks to South Africa. Thank you.
Thanks. Then let's proceed to the Accountancy and Actual Discipline Board investigation into BAE. That is page 9, paragraph 19 of your statement. Can you take us through that paragraph?
Chairperson, to the best of my knowledge, this investigation is ongoing, even though it was announced a couple of years back, and I've watched the media carefully, as have others. We haven't seen the outcome of it, but we know for a fact there is this investigation. It's an investigation that doesn't ask whether commissions were paid. It was asked the channels through which they were paid. And particularly, it's been asked to investigate the audit company KPMG as to how they organized the payments of these. So even though we don't know the outcome as to how these commissions were paid, it would seem that very powerful, very reputable bodies seem to agree they were paid. And let's hope that we get the findings from this investigation in the not too distant future, so it can add to the type of evidence which I am offering to you today.
Thank you, Dr. Woods. Then I think paragraph 20 is the paragraph that Mr. Cilliers was concerned about. It relates to the sub-investigation into the Gripens. And maybe let's now go to paragraph 21 and 22 in that regard, if you can take us through those paragraphs 21 and 22.
Can I get assistance from you, Advocate Lebala? This annexure GGW10, it's supposed to be on page 78. I can't find this page 78 on this document.
Commissioner Musi, page 78. I think it might have misplaced the document. We'll provide it for you.
Advocate Pa.
Thank you, Chair. May you then proceed? We are on paragraph 18. Oh, sorry, paragraph 20. My apologies.
May I just refer back to Annexure 10, GGW 10, and paragraph 18 regarding the BAE deal. The source here is the Mail and Guardian, by the country's, I think, generally two leading investigative journalists who have a very impressive track record in producing responsible evidence. They talk about documents they have in their possession, documents which were used by the Scorpions to motivate a particular raid. So all I'm arguing, I have a press article, but I'm saying, please accept it has some credibility. What it says, it shows, once again, it talks about the commissions paid to agents by the British defence giant and the huge amounts concerned, which is part of a theme which I've been presenting to you. The paragraph that follows is interesting, and I will refer back to this later. They also argue that BAE could not produce evidence of legitimate services by the agents which could justify the huge amounts paid to them. So people receiving these so-called commissions, British Aerospace are unable to say what they did for that money. I think it's an important point to note, as I'll later explain. The documents, which are affidavits by South African and British investigators, they are financial statements and correspondence, form the basis of the documents to which I'm referring. And they not only disclose the vast majority of BAE's commission payments, they also how the covert payments were made in a series of undisclosed to agents. Once again, if it was purely commissions, then it would appear in their books as commissions, and there would be nothing to hide. But that's not what happened here. Also, how BAE allegedly tried to hide the extent and the timing of their relationship with Hlongwane from investigators. Details of interventions by Madise and then defense procurement boss Chippy Shake, which also advantaged the BAE deal. That theme of Chippy Shake, which will be there to haunt us.
May you now proceed to take us through the ASAP investigation into the Gripens?
It's now, there was an objection early on to the use of 12B. So I'll only refer to 12A, but it says the same thing. And it says nothing about Richard Young or David Mania. It says what Saab's own investigation of themselves says, where they admit to guilt, they admit to bribe is being paid. I think that's pretty hard evidence, Chairperson. Sorry, not on the international investigations. I'm up to paragraph 20.
I just mentioning that, are you satisfied with your explanation, what you said in respect of the the sub-investigation to the grievance? Is it your contribution? Is it your contribution in respect of paragraph 2222 under the subheading sub-investigation?
By international investigation. Yes, that's the conclusion. But in summary, I'd like to make the observations that these were investigations made by organizations, by sometimes state organizations, sometimes other investigations, which by all accounts were independent and free from outside influence. And that each of these investigations have, amongst their wider findings, revealed dubious payments to have been paid to South African politicians, public officials, arms deal-related businessmen, and other middlemen. That's the constant theme.
Thank you, Dr. Woods. Then let's turn to page 10 of your statement. I think you then discuss the topic titled, Why Commissions Are Likely to be Bribes. Can you take us then through paragraph 23 and 24?
Yeah, I was informed that when former President Mbeki appeared before this commission, he suggested there was nothing wrong with arms suppliers paying large commissions to whoever they choose, and that's the nature of the business world. And no doubt there are others that hold that view as well. And no doubt the recipients of those commissions will also try and legitimize them. But I want to point out again, and most of the exposés in the arms industry as to where corruption has taken place has concerned bribes or commissions that were in fact bribes. So the word commission in the arms industry is most often just another word for bribe or kickback. So once again, President Mbeki didn't appear aware of that and how things have transpired in the arms industry and as they are recorded. But more importantly, if we look at the nature of how the South African arms deal was
It appears that the witness is referring to the evidence of President Mbeki without actually having read it, because President Mbeki never spoke of large commissions. One will search in vain in the records to find any reference to large commissions. And in any event, his evidence did explain the difference between a bribe and a commission. I think if the witness has to refer to evidence given by any other witness, I think it's important that he must have read that. Otherwise, the impression that's going to be given here is that he's quoting correctly from the relevant evidence.
I take their point, Chair. The word large shouldn't have been there, then I apologize for it being there. Secondly, the way the arms deal was constructed as a government-to-government deal, ultimately it was left with no scope for middlemen and no need for consultants, especially those who might otherwise be deserving of such large commissions and success fees. The official position of government is that the transactions were negotiated directly by the South African government and the suppliers. So in my opinion, there was no other role for anyone else to pay. And I refer back to a document I referred to a moment ago, that in the BAE deal, BAE said exactly the same thing, that they have no records of not very good at finding my documents, but I did spell it out before that BAE themselves say they never paid any, there were no such services offered that deserved such payments. Words to that effect. I can find the exact quote once again if you would like me to. So I'm
Great respect, I would invite this witness to bring the source from within BAE where they stated that there was no services rendered for the commissions paid. It simply doesn't exist.
Are you in a position to respond, Dr. Woods?
And it's perhaps not a relevant statement, but I'm sure that BAE would have sued the Mail and Guardian and demanded those documents if they were just making it up, as is suggested.
Dr. Woods, just listen to the question very carefully. Is there any evidence that you have which is going to back up that statement, that BAE agreed that no services were rendered?
So I referred in some detail to the evidence as is, and the documentation and the source as was quoted in the article. If you believe that's insufficient, I'm at the mercy of your judgment call.
Okay, let's proceed. I can assume that there doesn't seem to be any basis for that statement that BAE agreed that work was done and they paid large sums without any services being rendered. Can I assume that that is the position, Dr. Woods? Except, of course, referring to that Mail and Guardian article, if at all it does say so.
Chair, I would obviously prefer you not to assume so, but I think reading the article carefully, who wrote the article, where they say the evidence comes from, and that from that evidence, the argument that BAE could not produce evidence of legitimate services by the agents which could justify the large amounts paid to them. I think it would be wrong to simply discard that and throw it away.
No, apparently you don't understand me. I'm saying that, that statement does not say that BAE admitted that they paid large sums of amounts of money without any service being rendered to them.
Well, if the investigators who spoke to BAE says that BAE could not produce evidence, I would think by deduction BAE are admitting that they don't have evidence to show that there was reason for these payments being made.
Mr. Chair, if I can refer you to GGW 10, in fact, the same investigative journalist stated the contrary. On page 79, second paragraph, he in fact stated, BAE has consistently maintained it acted legally. That's a far cry from suggesting that BAE admitted to the Mail and Guardian or to Mr. Bremer that they paid large sums of commission without any services rendered. That has an innuendo of corruption. Here they clearly maintain that they consistently acted legally.
Dr. Woods, do you want to respond to that?
So if I had 5 minutes, I would wish to respond to it, but because I need to just get the context here, whether the gentleman is not interfacing two issues that don't belong together. to take one paragraph from page one and another from another page and to say they contradict, I think it requires one needs to apply one's mind a little more responsibly before making the deduction that he made.
So you need some time to read the Mail and Guardian article so that you can be in a position to respond to what Advocate Celia said.
Only if you would like me to respond, Chair. Because only if you would wish me to respond to the gentleman's point. I've already made my point in terms of my statement.
Now that I understand, but then my difficulty is this statement that he has referred to on this article, because whatever you have said, then you have based on this article. But then there is a paragraph there which says that BAE has consistently maintained it acted legally. And that seems to contradict what you said earlier on.
Yeah, I would ask, in what respect does the article say BAE has consistently maintained it acted legally? Maybe the gentleman could make up something from us there.
I'm not quite certain whether I'm going to allow that for you to ask Advocate to answer your questions. You're the one who relies on this statement. You're the one who put in this document in the bundle. And you are making statements arising out of this report. Probably you are the one who should explain to us, what does this mean? This is a document that we're relying on.
Chairperson, the statement raised was BAE it consistently maintained it acted legally. Acted legally in what regard? It doesn't say there that it acted legally in paying Hlongwana commissions. If it said that, then yes, there would be a contradiction in what I said early on, from the earlier paragraph. It doesn't say that.
Okay, it doesn't help us much. Advocate Kanpa, let's continue. That doesn't help. That answer doesn't help us in any way.
Thank you very much, Chair. Maybe let's conclude then this topic by looking at paragraph 25, page 11. I think it concludes the topic that we were discussing. Can you maybe take us through that?
Yeah, I express the views here, Chairperson, that surely there is enough that arises from these international inquiries to suggest that big monies were paid. And if you accept my arguments on the commissions versus bribes issue, why there was any need for big monies to be paid to individuals, both inside and outside the process. So the first question is, why did this happen? But I do conclude by saying, to me, it's incomprehensible as to why the South African government declined to contemplate the foreign investigation findings referred to it. I know the head of the Hawks claimed to have written letters to a couple of these investigators and claimed to have not read a response. But the arguments that came from SFO, for one, and the public prosecutor from Düsseldorf, two, I think there was a third as well, claimed that they had been unable to get the cooperation of the South African government. So I'm assuming the latter to be more plausible, and that for me it remains incomprehensible that the South African government didn't say, thank you for the good work you did, how can we cooperate? Let's together get to the truth of these issues. They did not.
Thank you, Chair. I see it's 1 o'clock and we are starting a new topic altogether.
Let's take a lunch adjournment until 1:45. Thank you.
Dr. Woods, do you confirm that you're still under oath? Say I do.
I do.
Thank you, Chair. Dr. Woods, thank you. We are now proceeding with the topic other substantive allegations on page 11 of your statement. Can you, as an introduction, just take us through the paragraph 26 and 27 before you deal with the sub-paragraphs A, B to D?
Yeah, thank you, Chairperson. So in the previous section, I offered a number of allegations made in the main by some key international investigations, and started to show there to be some consistency in the findings of those investigations. I want to build a little further on those key findings to show the patterns that other allegations have also alluded to. Again, I'm quite careful, I believe, in which allegations I'm putting forward. And I'm doing this in the interests of building my case to a level which makes it fairly convincing that corruption took place, that so many allegations from different sources, all having done their own type of investigation and research, that degree of correlation must say to the Commission, I believe, that there are issues here which we need to inquire more deeply into. We cannot ignore them. I'll also show in the third argument I present after this current section that when we look at the systems and the processes of the SDPs, and I show you very clearly where the weaknesses were, where the opportunities of corruption were, how strongly and how directly they connect with these very allegations that we're now discussing.
Thank you, Dr. Woods. Then can we go to page 12 and then you can start dealing with the submarine deal?
So I refer to a leaked government report, which is a report we haven't made reference to so far. You'll find it in GGW 13. It's about halfway down the first column. I don't know if I could be assisted with the reading of that paragraph and the two below it.
The page 91. Which paragraphs on page 91?
The paragraph starting the Mail and Guardian, and then including the two paragraphs that follow. These copies are very bad quality, I apologize, and my eyes are not strong enough to read them to you.
Let me read it for you. The Mail and Guardian has obtained a copy of a report by German law firm Eiken Lur Wuchek, dated February 2011, that focuses on the South African deal and exposes the company's own baleful assessment of the offset program. This comes as the Department of Trade and Industry has just released its final offset figures for the arms deal, which claims to show how Ferrostal not only met but exceeded its obligations. The department has consistently refused to reveal how it arrived at its figures, and the Heiken report exposes the contradiction between its claims and Ferrostal's internal assessment of key projects. Should I proceed?
If you could continue to the second paragraph in the second column, the second and third paragraphs in the second column, please.
Indicative of the real attitude of the German company was a calculation done by senior executive Wolf Rudiger van Tol, Ferrostal's Southern Africa chief, who took as this baseline that the penalty for failure to deliver the offsets was 10% of the submarine contract value, or £66 million. That meant spending anything more would be more expensive than walking away from the offset obligation. In the end, Ferrostal spent just £62 million, accounted for as contract expenses, but was credited with achieving a £3.1 billion in offset credits by the department.
Chairperson, I think those are euros, not pounds.
My apologies.
Yeah. Towards the end of my report statement, Chair, I have a brief section on the offsets, which I know is also a large part of your brief. And there one will indicate and give evidence of these paragraphs that have just been referred to, how they are a consequence of what happened in the evaluation period of the process, and specifically the evaluation of the NIPs for both the submarine and the frigate deals, where they appear to have been grossly inflated for reasons that DTI couldn't explain, other than that they said more points were awarded for Kucher NIPs than other NIPs. And if we look at what was promised by these companies, and they were going to be anchor tenants of Kucher, major stainless steel mills, we know that that never really happened. So I just tend to suggest there was something, because in both these cases, the frigates and the submarines, going from the forensic arguments of the JRT report, if it weren't for the very high points they scored on the offsets, neither of those two consortiums would have got those deals. So one has to question why the NIPs were inflated in such a way, in a way which were, as this article shows, were impossible to achieve. Secondly, so I just believe it's a contentious issue which deserves further looking into.
Thank you, Dr. Woods. Do you want to proceed then with the other paragraphs 29 and 30, or you want to refer to the other annexures referred to in page 20, in paragraph 28?
With your assistance, please, if you could help me with GGW 14, and if one could read the first couple of paragraphs of that article,
of the internal probe by Ferrostal.
The first paragraph. Thank you, Jim. Ferrostal, the lead company in the consortium that sold South Africa submarines as part of the controversial 1999 arms deal, paid more than $40 million, I hope I'm correct, Mr. Morani, to agents in South Africa whose chief attraction was their influence on politicians. That's one of the key findings to emerge from a devastating internal compliance investigation compiled for Ferrostal new management by international law firm De Bevoy and Plimpton. Other key findings of the South Africa section of the report, which the Mail and Guardian has seen, highlights concerns about Ferrostal's business relationship with Chippy Sheikh, the former chief of acquisition who played a central role in the tender process.
Yeah, sorry, I see this has strayed beyond the internal investigation and it's gone into the other investigation, which the judge has already ruled we cannot talk about. So I beg your pardon, we could just stop at that first paragraph and on the internal investigation, yeah. So that's adequate, thank you.
Thank you. Any further reference to any relevant paragraphs in relation to the submarine deal?
Yeah, I feel I'm at this stage, my report, a little bit walking on eggs because of the various reports and knowing that there is one report which I cannot refer to, so I'm a little bit difficult to unscramble that egg while on the floor. So I'm going to ask that we just move along, but ask that you have taken note of, once again, allegations of corruption and of manipulations in the process of who ultimately got awarded the business. So I think we could perhaps move to paragraph 30, if I may. Chairperson, you'll see the copy of an email which was purportedly written by one Greg de Munjuk, individual who I seem to recall interviewing at the time that the arms deal saga began to emerge. I'd also like to say that at that time, soon after the Dalal allegations, when it became apparent there were going to be investigations, there was a degree of panic in a number of quarters. And my former colleague Andrew Feinstein and myself were approached by a number of individuals who reported manipulations in the process and dishonest goings on. I appreciate that to refer to those would amount to hearsay, even though for me those reports were actually made. I actually heard them, I actually recall them. But we have one here on record.
Just to refer the commissioners to page 101 of the bundle.
This is from a known individual who was part of an evaluation team working on the submarines. And without reading everything he has to say, it was simply just another bit of evidence or information that we had this pretense of good practices, pretense of policies and procedures being followed. Yet what came up time and time again, as came up here, that there were people on the inside who could see that it was all a farce, and that decisions were being made elsewhere, and the nature of the process became how to achieve the predetermined result. And so people like Ms. Greg de Monek, just it's an expression of his frustration in this regard.
Thank you, Dr. Woods. That then concludes your contribution in regard to the submarine deal. Can you then proceed to the frigate deal on page 12, paragraphs 31 to 38?
Here we look at a number of annexures, beginning with Annexure 18.
Those are just those simply arguments which express a degree of indignation at the head of the Hawks deciding to withdraw from his investigation, and the arguments just endorsing a number of points I've made so far, that given the amount of evidence, circumstantial or otherwise, that existed, how how improper it would be that if certain people with the degree of suspicion that surrounded them concerning the arms deal would just be let off.
Sorry,
this I refer to 19.
Could you always refer the Commission to the pages and the paragraphs of what we're reading?
Apologies, we're on
Paragraph 31,
and I'm looking at the top of page
13, is it? Yeah. And I'm looking at Annexure GGW 19. The heading there, South African investigators are in possession of an explosive memo detailing a meeting where former arms procurement boss Chippy Sheikh allegedly asked for 3 million success fee from a German consortium which sold the country 4 frigates. The contents of the memo, as produced by the Sunday Times, was written by a former executive in the German frigate consortium by the name of Christopher Huynings, who said that, who spoke about the, if I could say, controversial visit of Thabo Mbeki to Germany in 1995, at a time when the GFC frigate had was no longer in the race. I think it had been disqualified. But how it would appear as a result of Mr. Mbeki's visit that instructions were issued to restart the frigate process and to reintroduce the
the GFC bid, which, as we know, ultimately won the deal. I would venture that that was irregular and that the process, when we get to it, of how the GFC won all adds up to say something doesn't smell good there. I go on to paragraph 32. We talk about how the Spanish bid, Bazan lost the deal through a manipulation of the evaluation process. And I refer you to an article, GGW 20, Politics Web, 20th of March 2010. It also picks up on the memorandum prepared by Christopher Hunings. And according to the newspaper which covered the memorandum, it says the last trip on a particular date was suggested by Chippy Sheikh, who was director of the Defence Secretariat. During one of our meetings, he asked once again for explicit confirmation of the verbal agreement made with them for payment to be made in the case of success to him and a group represented by him in the amount of $3 million. Hunings, it would seem, is reported to have said that he confirmed this to him, to Chippy Sheikh, and offered to record this agreement in writing at any time and proposed to put the latter in a safe so that it can be addressed jointly. The memo goes on to say, Mr. Sheikh has emphasized that and he mentions that Blom+Voss and the other part of the GFC consortium offer was pulled into first place in spite of the Spanish offer being 20% cheaper. The Spanish offset was, according to him, also higher than ours in this respect. It had accorded to him been no simple exercise to get us into first place. I think that speaks for itself. And as I've already mentioned, how they pulled it into first place was to make the GFC's offsets, the NIPS in particular, better than Bazan's, simply by using a different scoring method. If I could refer you to page 35. I do want to explain page 34. I was unable to find my document in this case, so I don't know what the term is, but I withdraw paragraph 34, seeing as I have no substantiation at this point. If I move on to paragraph 35 and show you on GGW 23 an email addressed to Richard Young from Theo Honeyball, who I believe was an admiral or some high-ranking official in the Navy, who goes on to confirm what we saw in a previous report that I quoted from. And if I could read part of this to you. He said, I was Chief of Naval Planning when Admiral Woodburn was, I think, Chief of the Navy. He said, as far as I'm concerned, the ROT, R-O-T, started when the then Vice President Thabo Mbeki. Briefly, you might remember that Bazan of Spain was identified as the preferred supplier of a corvette for the SAN. This was after Arms Corps and the Navy had been through the long process of proposals from many suppliers. When Vice President Thabo Mbeki went on an official visit to Germany, He returned to South Africa and told Armscor to halt the tender process and start again, and to give Germany a chance to tender again. By that time, pictures of Bazan's design, the frigate design, had been published in the newspapers, which I would imagine he's implying that would have disadvantaged the design. But eventually Bazan's team left South Africa in a huff. Germany got the tender. That's the story in a nutshell.
Person, it shouldn't be assumed because we are not objecting to each of these reports that we actually are not objecting. It's all in the interest of getting this witness to get to the end of his evidence. But I think our objections should remain on record with regard to all these allegations to which he cannot testify, based on mostly emails from Richard Young, whom I hope will make an appearance before this commission.
Mr. Chairman, may I, in order to speed things up, express the same views than my learned colleague. We are now going to start shortly with further allegations against my clients, and in order to speed things up, I'm not going to object each time. I see we are in a fortunate position here that we don't need courts and commissions anymore because we have the Mail and Guardian. But I suppose Dr. Woods will proceed with his evidence, but the fact that we don't object shouldn't be seen as a fact that we have no objection against the evidence.
We can proceed, Applicant Power.
Thank you, Chair. You may proceed, Dr. Woods.
Chairperson, of course, I welcome any objections, and I will entertain them as constructively as I can, at whatever stage. Whether they are as according to the one objector or from Richard Young, or whether they are as the objection from the other objector or from the Mail and Guardian, or whether they are from the various other sources I've alluded to, in which they can verify in their packs. Yeah, I have another one of these on GGW 24. I'm referring to a article, once again, which I found difficult to read due to the smallness of the. But this one comes from, I think, from the Business Day, and you'll see there's a good number of sources of the Business Day, documents. Yeah, sorry, I'm unable to read this, but I'm trying to pick up on the point where the subheading says hint of political maneuverings may expose winning tenders to challenge. Which I submit this for the Commission's consumption and for any value that it might add to my arguments that there are documents and accusations that there were untoward, as they say here, political maneuverings which could have affected the tenders. So I do submit it to evidence nonetheless.
Then we proceed to paragraph 37.
Yeah, page 14, annexure, sorry, 25, yeah, and paragraph 37, correct, yeah. So here the allegation is that the Thompson CFS met Chippy Shake shortly before the list was drawn up. And this again is from Business Day, not from Mail and Guardian, not from Richard Young. And
I'm sorry, Advocate. I'm forgetting. Dr. Woods, which list, short list are you referring to?
so I'm referring to an Annexure 25A, I think, or 25, in paragraph 37.
Which short list are they referring to?
Yeah, this comes from, I think, the evidence of Johan van der Walt, who was a key witness in the Shabir Sheikh trial. I think he worked for, was it KPMG or one of the other big auditing firms, Deloitte's perhaps, who presented evidence and who he said documents prove there were a number of meetings between the Department of Defense Chief of Arms Acquisition Chippy Sheikh and Thompson CFS before the list of preferred bidders was finalized. And this concerns the, if I remember correctly, the sort of platform or combat suite subcontracts which in which Chippy Sheikh's brother did rather well. And in which I think the Scorpions found confidential documents in Shabir Sheikh's possession. So again, I think it's material to mention this, in that the connection to Chippy Sheikh's brother, to the conflict of interest
Dr.
issue.
Woods, I understand that, but then which short list are you referring to? There were various short lists. I'm not quite sure when you hear it just says short list, that he manipulated the drawing up of the short list. What does that mean? I'm trying to understand that. Unless if you also don't quite understand it exactly what they mean, or which short list are they referring to?
Mr. Chair, I'm sorry, I seem to have pressed the button. I was placed on record this morning, Dryman, on behalf of Tylus, just simply to assert, and I think as your question and the lack of an answer shows, that the Tylus Group associates itself with the criticism of evidence being given through press reports.
May I give my response now, Chair? May I give my response? Yeah, I apologize for not picking up your point, but if you had said to me in the first line of chapter 30, of paragraph 37, it refers to short list, then I would have known what you were talking about. You were just using the word short list, so I was a bit confused, but I do apologize. Short list and short listing in tender language and in bidding language means that you get a number of suppliers who bid, usually in terms of predetermined specifications. Those specifications are evaluated until you reduce them down to a short list. There can be one obvious winner, and the short list might comprise one, it might comprise a few. So what they're saying here, before they reach that stage of the process, what is being said here by the investigation that took place, that Chippy Sheikh met with Thompson CFS. I think that's quite clear, and I think it will help the representative of Thompson's as well to understand.
Okay, can you proceed now to paragraph 38 on page 14?
Thank you. Thank you, Chair. Excuse my pausing. Yeah, paragraph 38 essentially is connected to the evidence in 38 is actually connected to the evidence in 37. And it says the awarding of many subcontracts to ADS and FBS. I think it is more ADS. I would need to check that. As politically connected companies included those. There's a typographical area, including those in the arms deal process. So, and I refer to you here in an article in the Business Day, dated 10th of January, Annexure GGW 26, where questions around what safeguards were built into the 43 billion arms deal to prevent any fingers being dipped, and this suggests there were pitifully few. What emerges is that the absence of proper mechanisms to prevent conflicts of interest, such as independent monitors, with stringently applied regulations, is a key weakness in the process. And we're referring here to information produced by the previous JRT investigation and the inadequate attention paid by the procurement team to potential conflicts of interest, even though interested parties were subjected to security clearance. They said material deviations from generally accepted procurement practice was discovered, and the Auditor General at the time also raised concern about possible irregularities in contracts awarded to subcontractors. So, and I see this is the Auditor General's initial review, not the JRT report. And you know, the article goes on to explain that the conflicts of interest concerned Mr. Chippy Sheikh and his family, and the fact that they got business. I won't read the whole article for you, but
Thank you, Dr. Woods. Then we can proceed then to deal with the BAE deal, paragraphs 39 to 44, when necessary with reference to the annexures.
Yeah, there's a repeat allegation of 1 billion rand being paid in commissions, including 250 million to Hlongwana. And in page 124 of the attachments, it refers to the evidence, once again, of the British Serious Fraud Office. And the evidence was damning, and that it included how the British arms multinational had splurged more than £115 million on commission payments, most of it through a secretive offshore network, alleging that Hlongwa received 250 million. Investigators attempted to ascertain whether Hlongwa made onward payments to decision makers, a task admittedly complicated by difficulties in obtaining bank records dating back as far as possible, as far as a decade. So that's one of those common themes which I'm sure we all know about, that the allegations of British BAE paying these commissions. And it adds on to earlier allegations which I've brought to the Commission's attention. Paragraph 40, the motivation behind the manipulation of the Hawks evaluation in order to award the deal. From IOL, I won't go into the content. I'll speak just in order to summarize what the point is that if we look at the JIT report, which I will be going into more detail, we'll see the extent to which the valuation of the Hawks was manipulated in order to contrive a particular outcome. And I think even more powerful in this IL article would be the evidence produced by the forensic team working for the JRT, which is in the next section that I'll come to. Okay, then I present some evidence in paragraph 41 and two articles which offer evidence of Mr. Hlongwane, besides any cash payments he might have received, having somehow built a not insignificant shareholding and its insignificant share portfolio, part of it with BAE companies, as I recall. On the following page, the continuation of 42, we see an interesting article on Hlongwane allegedly having bought a house for the head of the Sipiwe Nanda. I don't think he was, I'm not sure what his title was, Secretary for Defense or head of the Army Amateur. It was explained as a loan, that there had been some difficulty by some investigators in confirming that. But I thought it was interesting in that we would have that type of relationship. 43, we refer to unexplained deposits in Madise's bank account. Back to the Mail and Guardian. Annexure GGW 31, even giving us a copy of one of the bank deposits, and perhaps that's I can also offer that in partial response to my earlier arrangement that I would come back to you on any benefits received that we know of that were received by Mr. Madise, even though this one does seem to involve cash, whereas others might have been by way of offsets. I think this does offer some interesting evidence. Yeah, finally I come to paragraph 44, an article written by Tim Cohen of the Business Day. Who, amongst many other reports of people who got access to one of the earlier drafts of the JRT report. And of course that's a scandal in its own right. And many questions as to why the original report was as depleted as what it eventually, the final version turned out to be. Especially sections on BAE. But from the copy that was obtained under the Access to Information Act by Richard Young, it's there in black and white as to a number of serious and very dishonest maneuverings to hide the truth from South Africa, the truth that I'm confident this Commission is going to reveal. And it shows how the final version, as was tabled in the National Assembly, justifies the inclusion of a non-costed option of the Hawk. How evidence that were in the original draft and parts that were removed suggested the opposite. I don't think I need to elaborate beyond that, Jay.
Thank you, Dr. Woods. I think that then covers the BAE deal. Can we then proceed and deal with the Augusta deal from page 45 to 47?
Thank you. The Augusta deal, paragraph 45. I refer to evidence that showed that figures were manipulated during the evaluation stage of the Augusta deal. And this will become clear from the Joint Investigator Team's forensic information, which is in the next section I'll be presenting. One of the many instances where Chippy Sheikh amended tender criteria in a position as chair of SOFCOM, a committee which really did not have decision-making powers, which was simply there to evaluate bids or analyze the evaluation of bids and submit information up to the next level in the chain of decision-making. And I'm just harping on this a little because, and hoping that you recall how many times the name Chippy Sheikh comes up, whether it's inside the processes, inside the structures, or whether it's outside, meeting with suppliers on numerous occasions, and a number of those suppliers saying Chippy asked for bribes. And indeed that is one of the issues that came up with Bell Helicopters. I think it was the CEO, a very senior person in Bell Helicopters, who stated openly to a number of people, and I'm sure would be happy to do so before this commission, that Chippy Sheikh made it clear to him that if Bell wanted to stay in the reckoning, they had to pay a certain sum of money. The evidence here suggests that Augusta was happy to pay that sum of money, and I think the outcome of this process says all that needs to be said. In Paul Holden and Henny van Vuren's book, they claim that, and I do hope that you get them to change their minds, Chair, and that they will appear. We need the evidence.
Yeah, I can assure those that we can subpoena are going to subpoena them.
Thanks, Chair.
Those who are in South Africa, they will be subpoenaed. Maybe those that we might have difficulties with is those who are in London saying that they can't get visas. And those who are in South Africa, we will subpoena them. You can be rest assured, Mr. Van Vuuren will be subpoenaed. He will come and testify.
Chair, I believe the Commission, as well as the rest of us, are earnest in wanting to establish the truth. I believe that Van Vuuren and Holden have a contribution to make towards the Commission's work in our joint effort to establish the truth. And so I would be very pleased if they did appear before you. Chair, and as an example, they claim here, and obviously we have to assume they have information, that figures were manipulated to ensure that the Augusta emerged as the preferred bidder. This was done by means of inducements offered by Augusta to connected political individuals. And this is a statement which I believe Henny van Vuuren, according to this article, made at the press club meeting around about the 12th of November. If I can conclude the section then, Chair, I'm arguing and hope to have convinced you and others that there's a high degree of corroboration between each and all of these allegations, not only through the findings of the foreign investigations, but also amongst other information I've offered, and that this amounts to enough, given the nature and the consistency of these findings and the varied sources from which it came, to alert us to probabilities of corruption in the deals, and to encourage the Commission to deepen the inquiry into some of these.
Thank you, Dr. Wood. I think now you're proceeding to paragraphs 48 and 49, dealing with the topic you titled A Criminology Explanation of Why Corruption in the SDPs Was Likely.
So, Chair, I've argued my case as to why the industry is one in which a lot of corruption takes place. As an issue of the environment, of the context in which we are considering the arms deal. I've then argued about the evidence out there, whether circumstantial, direct, indirect, from newspapers, from articles, from investigations, from audits. I've argued that there's sufficient clear substance, that it's not just wild allegations. There's something that fits. There are some very strong themes which have emerged. And now I want to really argue the case as to why those issues we see emerging of bribes and the individuals and the companies involved, while they were not only possible, they were indeed likely. And I begin off by offering a criminological explanation of why corruption in the SDPs was likely. And there's something under the loose heading of crime opportunity theory, which is very well established in criminological textbooks. So the irrefutable logic established through criminological studies over many decades advises that for criminal action to have taken place, the perpetrator would have firstly needed motive, secondly, the opportunity through which to exercise that motive, but thirdly, it needs to be an individual who would be able to rationalize or justify their actions. So many of us might have motivation to want more money, for example, and opportunities might appear before us, but hopefully we are all of that type that say that wouldn't be the right thing to do. We can't rationalize this and we don't do it. So if you think about it, all those three facets are needed. If any one of them is missing, then the would-be perpetrators would be unlikely to commit a crime. The crime simply wouldn't take place, in fact. Now, the conditions pertaining to the first and the third, the motive and the ability to rationalize, let's just assume that they are part of the makeup of any would-be corrupt individual involved in any criminal action, including in South Africa's SDPs. And I think this assertion is well substantiated by way of the many recent cases of exposed public sector corruption in South Africa, where the motivation to dishonestly seek self-enrichment abounds, and where those who act corruptly display little remorse at having done so. And I think for this discussion, this leaves us with the issue of opportunity, and specifically, were there opportunities for corruption in the South African arms deal? And we always know there's, us being rational human beings, we don't necessarily just jump at every opportunity. We always, in our own way, do a risk assessment to see whether you want to take that chance or not. Some people are quite risk averse and wouldn't just grab at every opportunity to gain dishonest self-enrichment. Others would take greater risks. But the operative word here being opportunities. Now I want to move on to, if I may, onto page 17, paragraph 50, under the heading of evidence of why and how the SDPs were open to corruption. And as I'll demonstrate, the processes and structures through which the SDPs were processed offered many opportunities for corruption due to procedural weaknesses, administration failings, and poor oversight over the application. I have already referred to the poor oversight, particularly in the case of the Cabinet Subcommittee. And just to mention as an aside, in work done by the Auditor General before the JRT report, he drew examples of how structures and processes were constructed in most countries in dealing with large arms procurements. Ours attempted to replicate that in most respects except for one, and that was that in between the final expert evaluations and recommendations, which in other countries would have gone on to the equivalent of the cabinet, we put this clearinghouse body of a cabinet subcommittee, which, if one looks at it, weakened the process. It allowed in a less formal forum, it allowed the subcommittee to interact with officials and to get involved in the processes and just generally weakened the whole accountability arrangement. Excuse me for that diversion. Paragraph 51. Over many years, good procurement practice known as international best practice has evolved and is regularly strengthened through the ongoing collective international experience. This in order to discourage transaction-related errors and to mitigate against possibilities of procurement-related corruption. So today we don't all do it our way. There's a convergence of how we do everything in the world today. How medical doctors conduct their procedures and go across every area of human endeavor, one will detect this. But this indeed happens in management, it happens in accounting practices, it happens in auditing. We all learn from each other, we all share with each other, we've all put together international bodies which we communicate through, and that indeed is true of what constitutes best procurement and tendering practice. Corruption in procurement transactions is said by Transparency International to be the most common type of corruption experienced worldwide. So early on we looked at the fact that the arms industry, amongst industries, is, according to the research of these reputable bodies, the arms industry is the most corrupt. We now look at, within industries, we now dissect it and we say of what types of corruption that any industry might be confronted with, where would the most corruption take place? And here again we have Transparency International saying procurement is where most corruption takes place. So again we forewarned, not only about the industry but about the type of transactions or the type of dealings where corruption seem to frequent. By understanding the best practice systems and processes, our attention is at the same time focused on problems that can occur should particular aspects of best practice not be properly applied or well adhered to. And by deduction, we get to understand the possible exploitable opportunities that any practice weakness can offer. And to elaborate a little further, Chairperson, if we say, why do we have to do this? Why does best practice say we must do A, B, and C? If we contemplate that, we'll soon establish why that has become best practice. It's because, as I've explained, it's the result of the collective global experience of what can go wrong if you don't do that. So I'm emphasizing how important it is to employ these best practices and to manage them and oversee them and make sure they are applied to the fullest. I do annexure, under Annexure GGW 35, a copy of red flags for corruption document. I was one of the contributing authors to that, but as was the World Bank and as was an organization called U4, which is based in Norway and which represents 5 European governments' research effort into corruption. So I believe it has some authority. You know, we could go through each of those red flags and at the end of this section and ask ourselves, did we fall down on any of these? And I think you'd be shocked to see how many of the warning signs we just simply ignored. If I can move on to paragraph 53. It should therefore be asked if there were any significant weaknesses and resultant possibilities in the STP evaluation and decision-making processes. Here, very sound evidence will be provided showing that there was an abundance of such weaknesses, and further that there were many irregular and questionable actions which point to these weaknesses having been taken advantage of. And I think as evidence I present to you also amounts to pretty direct evidence. I think it would be very, very difficult to simply disregard it. Paragraph 54, my inquiry around possible weaknesses highlights a great number of procedural and control failings, which, as are found in almost every case of procurement or tender fraud, are definitely found, in the STPs. Paragraph 55, the evidence of these weaknesses and the opportunities these can provide for poor or dishonest decisions can be ascribed to the following 3 sources. So this is where I get my information from. And just to mention them up front, the first would be the initial review of the SDPs conducted in November 2000 by the Auditor General. Second will be the Joint Investigation Team's report a year later. And thirdly will be the testimony of Lieutenant General Pierce Staines before this commission. So this original brief report from the Auditor General, beginning with paragraph 56 and on the initial review of the Auditor General, and the annex here, GGW 36, stated material deviations from normally accepted procurement practices were discovered. See also in this regard, and to support this, is a Business Day article attached, GGW 37, which simply is an analysis by Linda Ensor of the findings of the Auditor General, where she, together with, I suppose, knowledgeable people that have it at the Business Day, have said, what is the significance of these findings? Because the Auditor General, as I said, conducted this brief review under a lot of pressure. Once the first allegations emerged from Richard Dillon, and a number of us jumped on the Auditor General, including Scoper, and said, we need to know, need we be alarmed or not? So he said he would do what he called a cursory review. And amongst the things he discovered, amongst the concerns, were these material deviations. He wasn't able to go deeply enough because he only had a matter of, I think, 10 days or 2 weeks to conclude this review, to establish what manifested from these weaknesses and whether indeed it had led to corruption or not. But he did go far enough to show us there were weaknesses, which, as I say, in Annex 337, we get an opinion that says they were potentially exploitable findings. I do mention that the contrast of the JRTs of this, the contrast of these findings are in contrast to the findings of the JRT report, where, and please note that I'm saying the initial report and talking about the material deviations, it contrasts to the JRT report findings, but is endorsed by the JRT's forensic work. I will explain in a moment why there's a difference between the two parts of the JRT report. It's forensic work and its findings. Anyway, the compliance failure issues identified by the review, and which are included in the review's report and in the related management letters, are listed in Annex 38. So I've included here firstly just a summary under 36 of, I think you have 36, you have the review firstly of the Auditor General. You have the Mellon Guardian's analysis, I mean the Business Day's analysis.
I think you're referring to page 145?
Yes, firstly I'm referring to page 135, which is the initial review by the Auditor General, in which he establishes sort of bad practices. I'm then referring to page 144, the Business Day article, which analysis talks about the consequences of some of those findings. Then I'm referring to page 145, which is GGW 38, which I'll start to list some of the key issues identified by the Auditor General in respect of weaknesses. But I also go on the paragraph 56 to bring your attention to the very important document, which is starts on page 146, which is what we know as the management letter which the Auditor General, when he does an audit, or when any external auditor does an audit, communicates concerns and queries to the auditee in order to give them an opportunity to respond. And you'll notice both in the letter and specifically in the attachments, we have I think it's in the range of about 20 or maybe a couple more procedural issues which the Auditor General felt strongly enough to bring to the attention of the department and ask them to explain themselves. So that is the first of the three sources I present as evidence of there having been major flaws and weaknesses in the process. I now move to the second one, which is the JRT's report in November 2001. Paragraph 57, it is well known that the findings of the JRT report were the subject of much criticism, as was the overall investigation. And this was due to a perceived pandering to the executive's anxieties regarding the possibilities of damaging findings. And that is borne out, I think, most people's opinions when they notice, firstly, the Auditor General's attempt to hide the fact that he was allowing the executive to direct changes to his work. Only when caught out did he admit to it. And then secondly, the Auditor General's denials that there were no substantive changes made. And then the efforts to get him to release the earlier drafts until he was threatened by the High Court on contempt of court and a possible jail term if he didn't release them, as he tried to defy the courts, which ultimately forced him to release an earlier draft, sections of which he blacked out. And we will never know whether that was the only draft. But it was enough to show us that that the JRT report, while we are grateful for what it does show in terms of the forensic investigation, it's really quite tragic as to what it doesn't show that was originally in it. Now, to explain this contradiction over the page in paragraph 58, nature of the Joint Investigation Team's report, it would seem to me, and from many newspaper reports on the JT report, they looked at the findings and concluded what it appeared that some people wanted them to conclude. There was no instance of corruption, that government were beyond reproach, that a few little issues here and there, but basically it was a very remarkably honest deal, the arms deal. But
so what is the relevance of the criticism leveled at the JIT report? What value does it add to your investigation as Commission? With great respect, we're almost through the first day and we're only halfway through with this evidence in chief. With great respect, there's no value added at this stage.
Advocate Parker.
Thank you, Chair. My understanding of the witness was that he was trying to go through these documents to be able to show that there were weaknesses in the processes and therefore there was an opportunity for corruption. I think on what he's trying to say, that's how I understand the relevance of the JIT report and his discussion there too.
Shouldn't he perhaps be brief for the JIT report? I mean, how many times have we heard about the JIT report? He's not the first witness to talk about the JIT report. He's not the first witness to talk about the Auditor General's report. I mean, we had so many witnesses who have spoken about this report. is it possible for the witness to try and summarize whatever he wants to say? Well, we have read those reports. Many people have read those reports. We do understand exactly what the reports are saying. Is it possible maybe to meet the concern of Advocate Sidley? Is it possible for the witness to try and summarize those findings of the JIT and the Auditor General's reports that he wants to refer to?
Thank you, Chair. Dr. Woods, I guess you heard the chairperson that we can just go through the summary of the report without getting into too much detail.
Yeah, there's a section at the end of the report which is called the suppression and disregard of relevant information, which I think is relevant to my arguments, and it ties up with why this does have value. It's also that I'm speaking and trying to cooperate with the Commission here to explain some things that transpired, which I have no idea whether you know about or not. So I have included them in my statement. But I'm trying to show you about the report had two sides and explain why. And I've never heard anybody else speak about this or write about this. Maybe it is familiar territory for you. So I move away from the findings, which I believe were contrived findings and which I believe were falsified the whole JRT exercise. I move to the second section, which was the forensic work, which were disregarded by the findings in the very same report. Sorry, I'm going to have to edit as I go along in order to meet your request that I speed up. But anyway, there's a substantial, well, there's what I call a profound disconnect between the actual investigations as are revealed in this report, and even more so in the earlier draft, and the findings offered in the final report. And how this gives a lie to the claim that there were no material deviations as the findings claim. So I'm talking about a sample of an astounding number of shortcomings discovered by the PricewaterhouseCoopers forensic work component of the JRT's report, and it's produced by Annexure GGW 39. It should be borne in mind that the highly appropriate executive-led editing of the initial draft of the JRT might well have removed reference to any number, to maybe many more of such findings. In fact, as we've proven, it did. If I could draw your attention to that page 163. And Chair, in wanting me to speed up, I do put on record that it is compromising my evidence. So can we just have that on record, please? So,
yeah, I think it's good enough if you've put it on record. If you think it's compromising evidence, that is good enough, put it on record. But I've made my ruling on that issue. Thank you.
Now, I accept your rulings that I cannot go through this evidence, which I believe is critical and fundamental, and which nobody else has spoken to this Commission about. The evidence I'm about to give you.
Dr. Woods, and let me also point out this to you. What you are making, you are not giving evidence. You are making submissions. In order to allow your evidence to flow, we have given you that leeway of making submissions even before you finish your evidence. The stage at which we are now is a stage of collecting evidence. We haven't reached a stage where people must make submissions. And that is why I made that type of a ruling. You are now getting into an area where you are making an analysis of various documents in order to present an argument. And we haven't reached that stage. The moment we're at a stage where you're supposed to give evidence and not to make an analysis of other documents and and present a submission. Nobody's stopping you from tendering evidence. We want evidence at this stage. We haven't reached the stage of submissions. All the witnesses that we have called up to now, they haven't made any submission. We're asking them to give us evidence and not make submissions. The stage of submissions will come at a later date. Maybe let me just clarify that, Chief, because now you get into an area where you are making only submissions. You have read the duty report, you have read that report, you then give us your view. You are not giving us evidence. That is why we're saying we want to give you that leeway, but at the same time, keep in mind that whatever you are saying, it's not evidence. But then we're prepared to give you that leeway. Just keep that in mind that, for instance, these other sections that you are not referring to the evidence of General Steyn. You are not giving evidence. You're referring us to that evidence in order to present a submission. And we haven't reached the stages yet. But then we allowed you to do that so that you can be in a position to let your evidence flow. I thought, let me make this point because I heard you saying that we're now compromising, you are giving evidence. You are not giving evidence, you were making submissions. The stage where we are now, you are making submissions, you're not giving evidence. But then we are prepared to allow you to make those submissions if you can expedite issues.
Thank you, Chair. Not being a legal man, perhaps that's the basis of my confusion. I felt that some early objections and comments by yourself called on me to give more evidence. I'm trying to make a submission that contains what I think is evidence. Maybe the legal definition of evidence is different to that of the scientific world. But I'm a little confused as to what I'm allowed to do and not allowed to do. But I've made it clear from the beginning that I'm trying to present and accumulate arguments and to demonstrate to you, because I don't see this as a criminal case where A presents their case and B presents their case and the judge rules. I see the nature of the investigation required here and the brief of the Commission to make its inquiry to perhaps allow a little more scope for witnesses to present their views, whether theoretical, whether partially substantiated or not.
Advocate Mbaga, let's proceed in the manner in which you are proceeding. We have made the point that we wanted to make.
Thank you, Dr. Woods. Let's proceed on paragraph 60. You were about to refer us to Answer GG 39 on page 163.
I do thank you, Chair, for allowing me, but in respect, I will try to go a little more quickly and not belabor the issues. Chair, the importance of this Annexure 39 is that it picks out views of experts, export forensic guys who have gone through the process, who had access to all the documents, and show us through the deals. And as I say quite clearly at the top here, this is just a sample of some of the irregularities and problems they discovered. But I just wanted to draw, I'll just pick up a few to show you the seriousness of it. If we talk about the submarine deal and we talk about a valuation formula change during the evaluation process, that's devastatingly improper. If I go to 6453 under the submarine, offers evaluated included unapproved business proposals. This is not in accordance with good procurement practices. Flaunting of the laid-down practices. Lack of supporting documentation and evidence, unsubstantiated assumptions for sales, no evidence of final scores. So I don't need to go any further, but I will if you wish me to. There are far more serious observations that were made to show you that the process, the very process of evaluation and decision-making was riddled with the most fundamental flaws, to the point that we have to accept that that we could have made the wrong decisions. And the nature of these flaws doesn't only suggest competence, it suggests purposeful manipulation. And where we see these gaps appear, as I explained, best practice is there for a reason. It prevents certain bad things happening. When you see the bad practice not there, it opens the door. It offers that opportunity for the type of corruption which I was trying to explain in the previous part of my argument, and also which is typical of that which happens in arms deal corruption around the world. So this, coming from expert forensic investigators, you know, I would love to have given you a closer analysis just to show you how it all ties up, but it would be time, yes. But I have confidence that the Commission will study this and will make those deductions themselves to show that this thing was wide open to opportunity. And how in some of the deals, every breaking of the rules advantaged a particular bidder consistently. So if we get the Hawke deal or the GFC deal, we'll see that repeatedly the mistakes were all in their favor until they came from nowhere to being top. It's all here. And we tie it back to, so where the allegations of the corruption were? We see how nice and neatly it fits. All of this together does not produce a smoking gun or conclusion, but I think it could help the Commission in saying, hey, there are the key issues that if we could answer those, we would be able to come up with a report that takes the country a lot closer to the truth than we've been before.
Thank you.
Can I proceed?
Thank you, Dr. Woods. I think the next topics relates to the Lieutenant General Perotaine's evidence before this commission. I think you've heard the commissioner, the chairperson, that this evidence has already been led. It's on record. If you can just summarize whatever views you have in respect of his evidence.
Yes, Chair, I respect your request. I interviewed Lieutenant General Perotaiне right at the very beginning, and so I was quite clear on many of the observations he had made and many of his opinions. Some of these, he was interviewed by the JRT, and he produced quite a big report, most of it which was in the original draft, but once again, because of its damning nature, was left out of the final draft besides 2 sentences. But fortunately, and I'm very grateful that the Commission called General Perotaiне, and I think some of the observations he made here, there must be about 10 or 11 of them, are very powerful. As Secretary of Defense is a man very close to the action, is a man seeing what's going on. These are his statements. And I'm saying, add him as a source to the JRT forensic work, to the earlier observations of what is the General Review, and through that I hope my argument prevails, the argument that the process, notwithstanding its impressive organograms and structures and claims to have procedures, that it worked. And we know this from investigations into any number of cases of public sector corruption, where we see the Auditor General ticks all the boxes that you have everything in place, yes, and a year later the Sunday Times produces evidence that that procurement deal was corrupt. So we've got to understand that that the processes, how they administered, and how devious individuals, especially those that have influence, can make a mockery of all the structures, the processes, the practices, and the compliance requirements. So I do, if I may continue on the next page, paragraph 62, I have summarized, but in the interest of time, I make my major observations here. And again, you'll see that these conclusions, this analysis, this summary of all the procedural breakdowns, just so happens to, once again, talk to the red flag lists I've offered you, happens to talk directly to areas of where corruption is known to take place in the arms industry previously, and talks to, very strongly, many of the allegations I've referred to, whatever their source. I ask you to jump right along to paragraph 64, please, Chair. And I revert back to the strengthening case which I believe I'm presenting, which involves the suppliers, which involves a number of individuals. And I suggest that at least 5 of the prime deals were inappropriately influenced and thereby wrongly awarded. And the likelihood being that such outcomes were contrived in order to accord with predetermined decisions as to which bidders would be awarded the supply contracts. This would, of course, render the entire process to have been a farce and an appalling exercise in deceit. So I then come to the end of the section, to paragraph 68, where I could have singled out a few individuals, but I do single out the acquisitions manager, Chippy Sheikh, just to show how through all this evidence and positions he held, I want to illustrate to you the position he was in. And I mentioned how he participated at virtually every level of the organogram that you'll see on, what is the page? 29. And I can take you into a lot of detail as to his involvement at the evaluation level, chairing the Softcom level, and going beyond his powers and making changes, as the forensic auditors tell us. His presentations through the AASB, the AAC, his secretariat, being secretary of the Cabinet Subcommittee, or being the presenter at the Cabinet Subcommittee, and to the Cabinet. I can elaborate on this whole situation in great detail and why it's in conflict, why it's so fundamentally in conflict with best practices as to how duty should be separated, how responsibility should be separated, and how those divisions of responsibility are part of the check and balance that any half-decent procurement process should employ. And if one looks at the minutes of a number of these meetings, it becomes very apparent what his influence is. And it bears out the allegation I made earlier on that almost all the decisions, bar one, were really made at the Softcom level. After Softcom had made its interventions, as the forensic auditors show us, and how that was sold upwards. Again, it was only the Hawke deal where Softcom proposed possibility of 2 choices. And I'm sure you're very familiar with the details of of how that worked its way through. He also chaired chairing of the Project Control Board. He was also a member of the INT, the affordability team. He was everywhere with great influence. And as I said, once he moved outside of the structures, he was sitting with the suppliers at both the prime and sometimes the subcontractor level. That ends that section of my presentation, Chair.
Thank you, Dr. Woods. I think now you want to take us through some few points, as you said, regarding the offsets, which are basically covered by paragraph 70 to 77 with reference to annexures. If you can take us through that.
Yeah, Chairperson, as it would seem, as with every other aspect of the processes, the DoD Arms Corps processes, the processes that dealt with offsets was also riddled with irregularities. I had a report done by a senior member of the Auditor General's office way back at the beginning who pointed out many of these irregularities, so I was forewarned. But many of the arguments as to why offsets are perhaps were also ill-advised. I'm sorry, I'm just trying to think of how I can summarize this. I think you'll have to forgive me, Chair. It's just 2.5 pages with double spacing, so it will only take a minute.
I think in the meantime, try and think about how you're going to summarize it, and we'll adjourn for 10 minutes. And during that 10 minutes, you can try and think of a way of summarizing it.
Thank you, Chairperson.
Thank you. We'll adjourn for 10 minutes.
Yes. Do you confirm that you're still under oath? Say I do.
I do.
Thank Dr. Woods. I think before we adjourn, we are about to deal with the issue relating to offsets from paragraph 70. Can you take us through that discussion?
Chair, when the President initially announced the Commission, in my initial meeting with the evidence leaders, and they met with other possible witnesses as well, it was suggested to me, because of some papers I'd written some 10 years back on the nature of offsets, that I might be useful to the Commission, given that a substantial part of the Commission's brief appears to be about offsets. So it was with that in mind that I put in this very brief section at the end, once again, in the hope that I could be helpful. So if you'll allow me, I'm just going to make a number of points about the offsets, about why they were perhaps ill-advised and why they were badly managed. And I do volunteer, or should it be helpful to the Commission beyond my duty as a witness to assemble information on offsets that's relevant, well-researched, well-substantiated information. You know, I'd be very happy to do that for the Commission. Chair, so I argue that the importance given to the IP component of the SDPs was excessive given the international experience. The IPs proved to detract from the actual procurement transactions, which were essentially about buying the right products at the best price. The evaluation of the IP projects by the Department of Trade and Industry, which are the NIPS in particular, as a possible means through which to make up for its failed industrial policy, was ill-considered given the international experience of the IPs. One will bear in mind at the time that the Minister of Trade and Industry was under a lot of pressure because his industrial policy had not taken off, his small business development not taken off, his competitions policy had fallen to pieces, and he didn't appear to be taking advantage of the very good macroeconomic environment which we give the then Minister of Finance credit for. So from things that the Minister of Trade and Industry said, we came to appreciate that there was a thought on his part that offsets were manna from heaven. It was an opportunity to really boost the economy and make up for some of the slowness in economic growth. Amongst other observations, the proportions of NIPS to DIPS was directly contrary to what made sense from a risk point of view. It's a fundamental issue that there is an international norm which I'll quote just now when I refer to the annexure, that shows that in arms deals, generally offsets became fairly popular, but then through experience 15 years ago started to get banned by an increasing number of countries. But for a while offsets were a common feature of arms deal procurements. But the norm I'm referring to is that the proportions of your NIPS and DIPS should always be that your DIPS are perhaps 7 or perhaps 3 times the size of your NIPS. And the reason for that is very obvious, that your DIPS are almost guaranteed because they're attached to the products that are being supplied. So in our case, if one of the DIPs was about Denel producing aeroplane wheels for the Grippins, then they couldn't deliver the Grippins without Denel doing that DIP. So the way you connect your DIPs to the actual suppliers makes them fairly certain. NIPs are a totally different story. That's why the norm is to keep them in the minimum. But we went the other way In fact, I think we broke the world record in the volume of NIPs, which proved to be, in my opinion, wild and woolly business ideas. And in my meetings and investigation into Eremachi and their original offsets on the NIP side, they demonstrated to me how easy it is to throw together NIPs, especially when the requirements from the South African side were very lax. They didn't require a full business plan, which you'd normally do if you wanted to start a new business venture. It was a very abbreviated, what they call investment business plan, which asked 3 or 4 things which you could perhaps do in the back of your cigarette box in a few minutes around any conceivable business idea. And it was one of the areas where I consistently asked for information of the Minister of Trade and Industry, which he always refused to show me. I said, I want to see credible business plans for these NIPs. Otherwise, they could just be pie in the sky. And don't forget, you sold the arms deal to South Africa on the basis of all the money we're going to make out of them. But later, I did get the specifications, and my worst fears were confirmed that there were never any real possible proper business plans. And and that simply gets back to the point that NIPs, if you're going to have NIPs, you should keep them as few as possible, and you should make sure they're as watertight as business ideas as possible. The original Auditor General's review, which I referred to earlier, stated that the issue of industrial participation played a material role in evaluating tenders. It constituted 1/3 of the total score of the total evaluation. We have noticed in 3 of the deals it was perhaps manipulated to be worth more than 1/3. The other 2/3 obviously being finance and technology. There were issue of guarantees, and which we noticed the international norm is between 5 and 10%. We asked for 10% of the contract price. But this appears to be lower when measured against the important role industrial participation played in deciding the preferred bidders. So the fact that we had so many NIPs, and then the way we even inflated the importance of the NIPs, it increased the risk. And I think there's a strong argument to say that the 10% was perhaps very low. The DRT offset audit conducted in early 2014, which was referred to, I think, in the testimony of Alex Owen, gives examples of 2 suppliers who would not have won deals were it not for their massive offset offerings. We must note that the original evaluation criteria did not allow for bidders to win contracts simply by offering offsets beyond that specified tender requirements. But here again, the criteria was inexplicably changed. The proposition that in addition to receiving products for money, one could also receive economic benefits worth 3 times the value of the products bought was always nonsensical and unprecedented in the realm of business. And I think you've all heard that argument often enough. The fact that DTI has to date not been able to produce business plans, and I mentioned this, would lead one to suspect that the proper business plans never existed, and that the NIPs were based on little or no viability studies, meaning their value and ultimate delivery possibilities were always speculative. And I think as the 2014 report shows, there's been a lot of offsets that have fallen by the wayside, a lot that have been changed, which are all within the conditions in the IP agreements. In reality, the situation means that suppliers, in order to not incurring substantial losses on the arms supply contracts, would either need to renege on their NIPs and suffer a modest 10% penalty, or would need to load their arms selling prices to compensate for money to be lost through the NIPs. And I see this was anticipated by the Department of Finance's affordability study, and I refer to paragraph 15 of Appendix C of the affordability report, and that would be in GGW 14.
and the affordability states, nevertheless, the risk remains that suppliers have already priced the present value of the NIP performance guarantees at least at its original level into their tender amounts. And Chair, I happen to have the costing detail of the Hawks and Grippins, which was given to me by Chippy Shake as confidential documents. And as I indicated, they appear to indicate a loading of prices. I haven't included those in my bundle because I don't know if I'm at liberty to, given secrecy and provisions. If I refer you to Annex 42, page 179, sorry, yes, but I'm going to halfway through the document, to 179 of the document which I wrote, which was a critique of the JRT report. When the JRT report came, I did two studies. One was critiquing the JRT report's findings to show how superficial and how dishonest they were. And then I wrote a second in that report, which I refer to later on here, which regards the interventions by the executive and the speaker, etc., which undermined Parliament and SCOPA in particular. But in this critique of the JRT report, I single out a number of issues of the offsets, and reference some of them to international. Go through to the detail, but page 179 and 180 would be what I would refer you to.
Thank you, Dr. Woods. I think that concludes your evidence or submission on the offsets. Would you then proceed to, Chair, I see it's almost 4 o'clock, and I just need your guidance. I have noted Advocate Morani's request, so maybe if you can give us guidance going forward.
I'm not aware of the from Advocate Morani.
Thank you, Chair. Mr. Morani just made a request that he is in the Supreme Court of Appeal tomorrow, and he would have appreciated, if possible, that he would have an opportunity to cross-examine the witness today. And it is on that basis that, seeing that it's about 4 o'clock, maybe he can make that request formally himself.
Thank you, Chair. I did indicate to the evidence leader that I'm only available today. In fact, I was not aware this matter could run over until tomorrow. Unfortunately, I cannot be here tomorrow. I'm actually in the Commission's hands as far as that is concerned.
Thank you. Let's proceed, then we'll come back to it at a later stage.
Thank you, Chair. Thank you, Dr. Woods. I think you may proceed then with the topic and the suppression and disregard of relevant information or of the evidence. That is paragraph 78 to 82.
Yeah, Chair, there are those that reflect on the arms deal and say, as I believe former President Mbeki did before this commission, that it's been 14 years and where's the evidence? I think there is a lot of evidence amongst that which I've offered earlier on today. But again, in view of the Commission and its task to establish the extent of the evidence, I thought it would provide a bit of context as to a significant part of the reason why hugely important evidence has not availed itself up until now. And I take you to paragraph 78, and I say, contention that needs to be challenged concerns that which claims that little evidence of corruption has been forthcoming regarding corruption in the STPs over the past 15 years. Paragraph 79. First, it must be mentioned that wide-ranging actions were taken to strategically prevent the establishment of primary evidence of corruption in the arms deal. Between the years 2001 and 2009, there were a number of interventions, mostly by the executive, which served to prevent or discourage the discovery of information which might otherwise have amounted to evidence of corruption in the 2000 South African strategic arms packages. And instances of this here include under 79.1, where I talk about the manipulations of SCOPA to prevent or discourage it from, and examples here, 79.1.1, to discourage it from fulfilling its obligation as per the Constitution, the rules of the National Assembly, and its specific undertaking contained in the National Assembly's 14th report of 2000 to use its powers to investigate aspects of the arms deal. I refer in this regard to a report I wrote titled Scopa's Intended Arms Deal Investigation, the Interventionist Causes of Its Failure. This is Annexure GGW 43, where I elaborate in some detail on these very issues. The second manipulation of SCOPA to prevent it or discourage it from 79.1.2 being given the opportunity to have the investigation agencies account to it either during or after the investigation had been completed to ensure effective oversight. As you might know, SCOPA was cut off from the investigating agencies, and the Auditor General banned staff of the JRT from talking to myself and Andrew Feinstein, amongst others. From SCOPA having its requests for SDP-related information, as which were made by its chairperson and members of opposition parties, positively responded to. And here, just to give you some substance, I refer to articles by SAPA dated 13th of June, Cape Town's 11th of June, News 24, dated 12th of June, etc., and the annexes 44, 45, and 46, where perhaps explain, if I could just explain, SCOPA had become a very effective oversight body and was having a really big impact on the management of finances across a range of large government institutions. We had taken measures that were unprecedented. We had corrupt people fired. We felt the Auditor General's work wasn't good enough. We rejected it and did it ourselves. We had a bunch of well-informed, well-qualified people, and I can tell you that most accounting officers were very afraid when having to appear before us, and they admitted as much. So we dealt with a number of big cases, and we're building this reputation. We're having this impact on the public sector, which hopefully would have led to less corruption and less other irregularities, until the arms deal came along. But when the arms deal initially came along, we were still in that vein. And as one unit, we said, let's get the Auditor General to do this review. And once he got a review, we said, no, these are signs enough to show that we need a deeper investigation. And we acted so quickly. We wrote this report. Well, Andrew and I wrote it. We did some research. I called for documents from the Department of Defense. Andrew and I spent a few weekends going through them. We explained to the committee there were some serious concerns. We needed the big investigation. We needed the 4 agencies involved. And we put our resolution through Parliament, and it was through before the executive realized what was happening. But within 2 days after putting that through, as one reads in Feinstein's book, the ANC component were called to Tainhase and reprimanded, and things started to change from there, where slowly, one by one, things were circumvented and marginalized. Not only the ANC component, but the systems, the processes. The Speaker's response, Andrew was removed from the committee, and amongst the things, and then where anybody in the committee wanted information on anything, especially the arms deal, the ANC component would say, we want to go and consult with members of the executive, and they'd come back the next day and say, the executives say no. So we vote that we don't want to see that information. And some of those press cuttings I refer to indicate that, but it is just another example of how information was suppressed. 7914, Scopa prevent from pursuing its interest in the SDP through the attempted intimidation of Scopa and its chairperson by the then Deputy President, and I refer to the same letter we spoke to earlier on. And I also ask you to look at my response to the letter, but I think there's no doubt that that was a very crude attempt by whoever wrote the letter to intimidate me and threaten me that I'd acted illegally and there would be consequences. Then, besides what was done to Scopa, there was the inhibiting of the work of the Joint Investigating Team, 79.2, by, firstly, 79.2.1, refusing the Special Heath Unit permission to participate in the joint investigation. Now, I attach in this regard an article in Business Day, well, it's a series of articles, dated 26th of June, attached as Annexure GGW 48. And that was the original wish of Scopa to have the Special Investigating Unit, which was under Judge Heath at that point, included in the investigation. And we had very particular reasons for that, because of certain features of his legal mandate, which other agencies didn't have. Also because he had a very accomplished forensic unit, which the Auditor General didn't have, the NDPP didn't have, the Public Protector certainly didn't have. And so we wanted him included. But he was the only agency that required the permission through a proclamation by the President. When that was not forthcoming, the Auditor General wrote to me, and I still have his letters asking me to please approach the President, because Heath, who had been in early discussions with the early team, was making a very good contribution, and they said it's imperative that he's there. I wrote to the President, and I was reprimanded by the Speaker of writing directly to the President. But eventually the President appeared on TV and firstly referred to an argument which had been put forward by the then Minister of Justice regarding a constitutional court ruling about the SIU not having been headbutted by a judge, and they tried to use that as a reason for excluding. But when half the legal world came down on them, President Mbeki in his TV interview referred to an investigation he had done, I think, by the then Judge President or Attorney General of the Western Cape, Khan, and an advocate, I guess by the name of Libba. And he quoted from that in his TV interview to say, you know, given their advice, he would not include the SIU. Somehow that report was leaked, maybe by Khan and Libba themselves, I don't know. But it is what you see in this attachment here, which shows that the President to have been very incorrect in his interpretation of what they said. In fact, they go as far and as clearly to say, as they too say, it is imperative that a unit such as that, the Heath Investigative Unit, be included in the arms deal. So I cite that as just one amongst the many issues I'm bringing your attention to. Also, the intervention of the executive, which affected information, was the holding of inappropriate and secret meetings with the heads of the 3 participating agencies, as was exposed by the Mail and Guardian newspaper, and the eventual editing and sanitizing of the final JRT report, which amongst other things declined to follow through on any of the irregular findings made by its forensic component. And so once again, Mail and Guardian were correct, as newspapers have been in exposing all the biggest issues of corruption over the last 10 years in this country. That's where we found out from. They produced the investigation and the facts which proved to be true. So I think we should be cautious about demeaning considered newspaper articles as simply being newspaper reports. And as I say, this one too, the Auditor General had to admit that the Mail and Guardian was correct. He first attempted to suggest that it was under a particular, under the then Auditor General's Act, that when it came to the Special Defence account, he had to confer with the Presidency and the Minister of Defence. When it was explained to him that he was legally incorrect, that provision in the Act only concerned audit reports, audits of the finances, as in the annual audits of the Department of Defence and the Special Defence account, and that in this particular instance, this wasn't an Auditor General report, it was a JRT report. It was a special initiative which didn't fall fairly and squarely in his act. So he changed his story, and then he said, oh, it is good practice that he had to, as with his first report, engage in discussions with the auditee to see whether there were any queries about these findings. He claimed that that was the case. But once again, he was using audit practice technologies which didn't really apply to forensic investigations, especially a forensic investigation where the auditee or the people one is really looking at to see whether they were at fault or not. And that as SAICA, the South African Institute of Chartered Accountants, lays down, if you want to, when you do consult with the auditee, your management letter should always be in writing. You must have that paper trail. There was no paper trail for the JRT, and as we learned from getting the earlier draft, that it was just a spontaneous effort of people saying, how do we change this damn thing to not get into so much trouble? So I state that it was a highly inappropriate, that intervention, and once again compromised information that could have told us about more about the truth, and the truth might have involved more direct accounts of corruption. I also talk about the failure of government to cooperate, as I believe they should have, with the international investigations, and to try and establish more about the alleged substantial sums of unexplained monies that were paid, that were claimed to have been paid to South African parties. And so I'm saying it's by design that all these interventions made it very difficult to discover if anyone had improperly benefited from SDPs, because the key sources of information come from those sources. They're in those records, in their records. And so it was very difficult to discover if anyone had improperly benefited from the SDPs at any of the prime contract, the subcontract, or the industrial participation levels. You know, so that's why I say it's disingenuous of former members of the executive to say no evidence of wrongdoing in terms of the arms deal has been produced in the past 14 years. This evidence of the above interventions by the very individuals who are responsible for their being proper and honest SDP transactions begs the question of why they made such extraordinary efforts to keep important SDP-related facts out of the public domain, while at the same time claiming there was nothing to hide.
Thank you, Dr. Woods. I think now you are almost there, and can you just take us through your then concluding comments, the last paragraphs?
Thank you, Chair. Paragraph 83, and if I could read directly from my statement. The statement presents a range of circumstantial and other indirect evidence which together indicates that corruption in the South African arms deal was not only plausible, but was very likely. The management control and executive oversight of the procurement process were such that they appear to have invited opportunistic activity of a corrupt nature. The evidence presented to substantiate this situation is almost irrefutable. However, it is when one, on one hand, contemplating where the most likely opportunities of corruption existed, and on the other hand, looking at the most credible allegations of actual corruption, that correlations are noted, which are undeniable. In other words, it so happens that the most obvious opportunities for corruption are those which the strongest allocations indicate to have been taken advantage of. With the many weaknesses in oversight, control, and the actual evaluation and selection processes in mind, it is believed that the evidence presented shows a serious incidence of manipulation of the selections of particular bids. This most probably in accordance with decisions which were premeditated as a result of bribery or kickback deals which were struck between agents of suppliers and politicians or public officials. As in most cases of bribery, such deals could have been initiated by either side.
Dr. Woods, just hold on. Paragraph 85, are you in a position to give us more details, particularly with regard to the last two sentences of paragraph 45? 85, where you say that, you know, as a result of bribery or kickbacks deals which were struck between agents of suppliers and politicians stroke public officials. Are you in a position to give us more details about the politicians and public officials that you're referring to?
Firstly, what you missed is say this most probably, so I don't make it as a statement of fact. And if you look at the context which I've offered you, my whole statement and the evidence that I believe I've been presenting all day, and these are the deductions I'm making. So I think I find your question quite difficult to respond to. But I do invite you to pursue your point of view through you, Chair.
Just from my own understanding, I don't understand it to be saying that you've got direct evidence which implicates politicians and senior public officials. You're saying that from these factors, a deduction can be made that probably these politicians were paid. You don't have any direct evidence which deals with that. Eh?
I do want to do justice to your question. Through the chairperson, could I ask you just to repeat it one more time? I do apologize.
I'm saying, am I right to understand that you be saying that from this scenario that you have given in paragraph 85, you are making, drawing certain inferences which brought you to a position where you say that public officials and or senior politicians were bribed? You do not have direct evidence which indicates to that.
That is correct, Chair. Sorry, I thought the question was coming from this side, so I was a little confused, sometimes with the mics. So I apologize, Chair. Yes, Chair, this is just my deductions that I make, which I take full responsibility for, which I don't state as inconclusive or as absolute fact. But these are my deductions as the way I summarize my evidence. And of course, I'm hopeful that you would summarize it and see it in the same way. Paragraph 86, what has long been needed, in my opinion, is an extended forensic investigation and what we call join the dots, if possible, between the JRT forensic work, what it revealed and what it points to, and what the main allegations indicate. So, for example, there's a serious allegation which appears to be well-founded that says so-and-so received a bribe, and we go back to the forensic work that was done in the JNT, and it's saying here there were many manipulations which allowed for types of interventions which would have opened the exact opportunity that we see in other deals, arms deals around the world where corruption took place, to have entertained that bribe. So I'm saying there's a slight disconnect, and I'm saying it would have been desirable that the forensic investigation of the JRT had followed that through, but they were stopped. But I'm hoping that one day somebody else does that work. I'm saying there's further need for forensic investigation into who benefited from the allocation of subcontracts and who the beneficiaries were that received the NRP-related business. This in order to detect whether there was any inappropriate distributions of business opportunities. So that would be another approach to saying the SDPs were all about getting business. Some people got the big business, that's the prime contracts. A lot of people got billions in subcontracts, and a lot of people made a lot of money out of the businesses that came from the NIPs. I think it would have been a worthwhile exercise to say, let's see who got all those business, got all the business. Of course, we know most of it in the prime contracts, and where of course there's further investigation needed. But in the subcontracts and the IPs, virtually nothing has been done. Paragraph 87, I do recognize that a judicial commission does not readily undertake forensic type investigation. Even though when I read your act in the brief, it does appear that you have the authority, should you so wish, and should you so decide to initiate some forensic investigation. But as I say, I do accept that a judicial commission is more likely to rely on judicial processes. So judicial commission gathers existing evidence and related information from those who testify before it, and maybe from other secondary sources. It does this in order to try and establish a strong enough picture which, at least on the balance of probability, indicates what took place. And it's hoped through my submission and the evidence that I believe I've offered will contribute meaningfully to the efforts of the Commission to achieve an understanding against which it can produce substantive findings. Thank you, Chair.
Thanks, Dr. Woods. Linked to the term of reference that you were giving evidence upon is the question about whether then should the Commission find any evidence of corruption, of bribery, should it cancel the supply contracts? What is your view on that?
Yeah, I was aware at one time of the 4 components which we nominated for the JRT, that the Special Investigation Unit was the only one that had the legal right to cancel contracts. But I do know in the prime contract there's a clause that says, if, to words to the effect that if corruption is found, South African government has the authority to withdraw contracts. But I'd look at this stage of delivery of the prime contracts. It's perhaps a little. I don't know if that's a viable option.
Thank you, Chair and Commissioner Musi. That did be the end of Dr. Woods' evidence in chief.
Thank you. Who are the parties who are interested to cross-examine Dr. Woods?
Couple of questions as well, Mr. Chair.
Chair, on behalf of the Department of Defence, I would like an opportunity just to take some instructions overnight, and the probabilities are we will have some questions.
Chair, on behalf of TALIS, again, one would take instructions overnight, but I suspect there will be a couple of questions.
I've got 3 people. Advocate Moran, Advocate Sidley, Advocate Kane.
Chairperson, the DTI would also like to pose a few questions to Dr. Woods.
Thank you. 4. I think there was a gentleman who was talking here. I couldn't quite hear. No.
Yes, Mr. Chairman, sorry, that might be a bit better. On behalf of TALIS, there might probably be a few questions we would like to ask.
I think there are about 5 people who will want to cross-examine Dr. Woods, and from what I could see, probably 4 will have to do it tomorrow, and only allow Advocate Morani to do it today, because of the difficulties that he says he has. Is there any objection to those arrangements?
Not from our side.
Thank you.
No objection.
Thank you.
Sorry, no objection.
Thank you.
No objection.
Thank you. Advocate Moran, how long do you think you're still going to be?
Chairperson, in the light of the totality of the evidence of Dr. Woods, I don't think I'll be long. There are issues in respect of which I would have loved to have had more time, particularly with regard to the bundles which were only handed to us during the course of this morning. But as far as this afternoon is concerned, I'll try to be very brief.
Advocate Mara, I'm not pushing to be very quick. I'm just trying to find out more or less what sort of time do you need to cross-examine. We just want to make a decision whether we should take 5 minutes adjournment and come back, or whether we should we'll continue with you until we're finished. Then that's the only reason why I'm asking that question.
Probably not more than half an hour, Chairperson.
Okay, then we can continue.
Thank you, Chairperson. Dr. Woods, if I understand your evidence, it really consists in a particular thesis. And the thesis is based, firstly, on the theory that arms procurement decisions are usually attended by fraud and corruption.
Through you, Chair. I quite like the way you put that. In a way, it is a thesis. It's the gathering of a lot of information in trying to answer a specific objection, or a specific research question. So I'd go along with you that far. But I think it would be unfortunate if you took my statement a step beyond where it actually went to. And I did speak to this early on, that I said my reference to the arms industry and the reputation it has, and I mentioned the major organizations in this world who accord it that reputation, whose research shows it's earned itself that reputation. All I say is that when we look at this investigation, we must acknowledge it's in a particular industry which has often been beset by corruption. That should prejudice or color our approach going forward. It should just be, we should learn from past corruption in the arms deal, which could give us some little warning signs which we could look out for. If they don't exist, they don't exist. If they do exist, then they do. But to say that arms deals are usually attended by fraud and corruption, I can't quantify it. Usually would suggest, I know it's if you'd said frequently, I would have said yes, the body of research out there in literature and proven fact would suggest it is frequently accompanied by fraud and corruption. But I wouldn't go as far as saying usually.
Well, but that is your major premise, that the arms industry, the process of arms acquisition is attended, whether you use the expression usually or sometimes or often or rarely, but your major premise is that there is this element of corruption and fraud attended upon this process.
It's not my major premise, but it is an argument that are presented together with a number of other arguments. And I think the other arguments were far more major than that particular one. But I thought a reflection on the industry does give us some background. And where in my citing allegations of corruption, or where in my giving evidence of vulnerabilities in the processes, where it happens to correlate to what has characterized the arms industry, then I say, just observe that, amongst other things. So I can't agree that I should elevate my explanation of corruption in the arms deal, in the arms industry, as being something more than what I have.
So I understand you, Dr. Woods, to be saying that because of all the factors that you mentioned and circumstances that appear from your bundle and your evidence, there was probably corruption in this arms acquisition process.
You're correct. I state that quite clearly in writing on a number of occasions, that my deduction from what I've put together here would be that there was probably corruption in the South African SDPs. Yeah.
Now let's refer to the particular people that I represent, and those are President Mbeki, Minister Manuel, former Minister Irwin, Lekota, and Casseroles. You are not saying that any of those persons was involved in any corruption.
Of the names you mentioned, I think I heard you correctly. No, I'm not saying that. And in fact, I have defended President Mbeki. I observed him for many years, and not that I'm the ultimate judge of character, but self-enrichment has just never been part of his makeup as far as I could observe. It just would surprise me, and I'd say the exact same for Ministers Manuel, Minister Irwin, and for Minister Casseroles.
And Lekota.
I beg your pardon, and Lekota. Sorry. Sorry, Tara.
And I think, as you fairly conceded, you are not presenting any evidence of a smoking gun. You actually have no direct evidence of corruption.
Yeah, I know in legal language, direct has a specific meaning. But if I know what it means, then you would be correct. Even though I've tried to suggest at parts that we are referred to an investigation that has been done and has proven something, to me that is fairly direct. It's less indirect. So I suppose there's that level of information where there are facts on the table which have been admitted to. For example, that came from some of those international investigations. Then there are what I call the substantive allegations, where a number of which came from media investigation. Yeah. And hopefully I didn't go beyond that.
I'm sorry, Advocate Moran, just for my own understanding, if you can repeat the question, because I don't understand the answer. The question was, is there any direct evidence that we have dealing with corruption? There was a long answer which I didn't quite understand it. Can you just rephrase that question or put the question again so that the witness can answer it in a manner in which we can also understand it?
The question was actually a suggestion which anticipated a certain answer. And the answer which I anticipated was that you are going to agree that you do not have any direct evidence of corruption in the arms procurement deal, you yourself.
Yeah, I don't blame you, Chair, for being confused, and it's partially my fault. But as I indicated, it's because you could help me, whoever, if you could just define for me what in this discussion direct evidence means, and then I could give you a yes or no answer.
Well, direct evidence Dr. Woods, would mean evidence to which you are a witness. In other words, evidence in respect of which you are able to give direct evidence, not hearsay evidence, something you have heard from somebody or something that you have read in a newspaper or some other article.
And it's direct evidence of corruption. Because a number of issues I've raised today, I've seen the documents that that inform what I've said. So that would be direct evidence, because I personally saw it. I personally saw the costings of the walks. I personally have copies of it. But if it's direct evidence of corruption, thank you for your explanation, and my answer is no, I don't.
Thank you. You referred to, I think it was Annexure GW 3, I think it was, on page 45. Now, this is a letter which was signed by the then Deputy President, Jacob G. Zuma, leader of government business. You see the signature on page 56. Now, this appears to have been a response to a letter which you addressed to the President, dated 8th December 2000. You see this on page 45.
Is there a specific question or point you would like me to speak to?
No, I'm asking you to confirm that this was in response to a letter from you to the President dated 8th December 2000.
I can't speak for the Deputy President, but yes, I do acknowledge that the letter begins with reference to my letter. But if we look at the letter, which is rather a lengthy letter, it raises multiple issues which have nothing to do with that letter. So I would agree with you in as far as saying that part of this letter was in response to my letter to the President, and it's the part that speaks to the Heath Special Investigation Unit.
Is it correct that to understand this particular letter in its proper context, it would have been necessary to annex the letter that you wrote to the President?
And I agree. I apologize for the omission.
Do you have a copy of that letter?
I do, and I believe I furnished the evidence leaders with such a copy, but because I didn't reference it in my statement, obviously then there was no need to include it in this bundle. But I do apologize for the omission.
Do you perhaps know whether that letter is readily accessible right now?
No, Chair, we may have to adjourn to get the letter. We don't have it in our possession.
Chair, I don't know how long it will take to obtain a copy of that letter. It might be important to.
And we can park 10 minutes, will that be okay, or 5?
Maybe 15 minutes, Chair.
15?
Yes.
Then we'll adjourn for 15 minutes. Thank you.